Yes, please. Yes, yes.
Okay.
Please carry on.
Thank you. A very, very warm good afternoon. Indeed, the entire weather and the economy is hot and warm. We all talk about sustainability and preserving the environment, but I understand, and we all understand that how much uh, we will be able to do when the entire world is so upset and things have taken a different direction altogether. But we are so fortunate to be living in a country that is India, Bharat, where India is talking about development versus so many other countries and nations talking about destruction and things like that. So, a big thank you to the current dispensation, to their strong leadership that we feel very secure in our own country. We from IPA is also today talking of strengthening the framework and the processes, which has come out vividly in the discussion paper on the COC's oversight and procedural clarity. And we are also going to talk about the amendments that has come on the 25th of February, 2026, not only in CIRP, but also in PPIRP, also in liquidation process, voluntary liquidation, and so on and so forth. You will love when you see the kind of amendments that has been made. More so, it is so much on the valuation aspect, which has been a big contentious issue. And when you see the discussion paper, I'm sure you will feel a little overwhelmed, but I'm ensuring you and assuring you that when Manojji and Nipunji, and of course, if I also jump the bandwagon at times, if we are able to dissect it well for you, you will actually dedicatively feel that this was much required. So let's just get into it. I'm very grateful to Nipunji, who's come to IPA for talking on the subject. Deep gratitude, Nipunji. Your expertise has always been something which people have admired, and you speaking from the heart and your experience merged together will surely bring benefit to all our audience. And of course, Manojji is our respected president of IPA. I'm sure he will take us through his own style that he will have to take us through first through a bit about IPA, and then we will straight away get into the subject. So without much ado, I'll straight away give it to Manojji to take us forward. And I also thank all the esteemed people, esteemed professionals who has joined in. I can see some very senior resolution professionals or insolvency professionals and lawyers who have joined in. I know Mr. Vijay Kumar, Shantanu Ray sir, Mr. Arora, Mayank ji, Rajesh ji, and there are so many others. Neeru ji, Sandeep ji, Deepak ji, Satyaprakash ji, Rajiv Prana ji, Mr. Rao, Harshit ji, everybody. Thank you so much. Please pardon me if I'm not able to take all names, but we are all grateful for your kind presence. Manoj.
Thank you very much. Thanks a lot. चाहता हूँ कि प्लीज अपने वीडियोस ऑन कर लीजिए सो दैट वी वांट टू सी योर फेसेस आल्सो. अभी हम लोग कुछ लोगों को नाम से जानते हैं, लेकिन पीछे जी हमारी काफ़ी मेंबरशिप बढ़ी है, तो बहुत सारे लॉट ऑफ न्यू फेसेस आर आल्सो जॉइंड अस. Only thing is that when we be able to see you by face, we be able to recognize you in all other platforms. Mamta ji, just give a little bit of brief of Nipun ji, our honorable
No,
guest today.
okay, okay.
Our honorable guest today, please.
No, no, I will. Thank you for that. Nipunji is holding a lot of degrees. He's otherwise a practicing advocate. He's a CS, he's a CA, he's an LLP and an LLM in corporate laws. He's certified forensic person. He's independent director. He's an executive. He's done his quite a lot of studies. He keeps on doing, and he's also done his PhD from Washington University on insolvency laws. No wonder that he has such a clear and deep understanding. He has contributed a lot of research papers, etc., on the subject and otherwise also on different other subjects. And he is an expert member in a lot of forums, including one of the ICAI. And he's written a lot of books that we're aware. He's written also one on judicial pronouncements on insolvency code for the year 2023. And he also regularly writes on RERA. I remember getting a book also, a very thick book on RERA Case Law Digest. So I'm also very keen to understand about RERA, because understanding RERA not only helps you to practice in RERA, but also helps you to solve these insolvency cases of real estate in IBC world. So RERA is definitely a great combination, and he has been awarded by the Divya Bhaskar, which is a very big newspaper group there, for excellent contribution in real estate justice. He is a regular speaker. He's regularly featured in the television. And most importantly, about everything else, above everything else, is that he's a social activist and also an RTI activist. So welcome to you, Nikunji. And we wish you that you keep doing such work for the society at large. I think that's the biggest earning that a person has and the biggest contribution that a person can make to the society. So, well, yes, Manoj.
वेलकम निपुण जी, वेलकम निपुण जी। तो आज की जो हमारा जो सिस्टम रहेगा फॉर ऑल 5 अमेंडमेंट्स एंड सीओसी के ऊपर है। तो मैं यानी कि बेसिकली आई बी टेकिंग इट ऑल द अंडरस्टैंडिंग लेवल, and with that all of you don't think that Nipun ji, Mamta ji is only panelist and expert there, and Anil Golji will also be joining. He just told me or only panel, but you all are also there, because जो ये चेंजेस अभी प्रपोज करे जा रहे हैं सीओसी के ऊपर, आई जस्ट टेल यू, जो अभी ये रेगुलेशन आया है वैल्यूएशन के, ये इसके बारे में दिसंबर के अंदर ये प्रपोज्ड डिस्कशन पेपर आया था। उसमें से कुछ चीजों को उन्होंने रख लिया, कुछ चीजों को नहीं रखा। बट जो अब ये सीओसी का ऊपर डिस्कशन पेपर है, इट हैज अ फॉर फार रीचिंग थिंग्स फॉर वी प्रैक्टिसिंग इंसॉल्वेंसी प्रोफेशनल्स। नो डाउट टुडे इज द लास्ट डेट। उस चीज को आपको पोर्टल पे जाके उसको अपने ओपिनियन देना है। बट that is why we kept it today, because immediately after closure of our meeting, you please log into the IBBI website, and make your perspective very clear to them, because इसके अंदर कुछ changes इस तरह के प्रपोज करे जा रहे हैं, जो कि विच वी शैल लर्न इन अनदर एन आवर्स टाइम विद म्यूचुअल डिस्कशन, कि जो हमारे लिए काफ़ी फार रीचिंग है। We insolvency professional is called as the one of the four pillar of the ecosystem of IBC, but this इस पिलर के ऊपर ना कुछ बोझ दिन ब दिन ज्यादा ही पड़ता जा रहा है। और जब ये इतना ज्यादा बोझ पड़ता जा रहा है, तो समटाइम्स वी फील कि सफोकेशन आल्सो। And if these things are get implemented, and if we want ki those should be implemented in an improved manner, we must put our perspective by logging into the IBBI website immediately after the conclusion of our this webinar. Okay, now let me start formally sharing my PPT, please. This flyer, everybody has received it. I'm moving forward. Yeah, today's topic is discussion paper on strengthening COC's oversight and procedural clarity under CRP Regulation 2016. We shall deal with 5 amendments and regulations. First one is insolvency registration process for corporate persons. In short, we call them as CRP amendment. Then we shall look into bankruptcy process of personal guarantors to corporate debtor regulation. Third one is PPRP, prepackaged insolvency resolution process. Fourth one is voluntary liquidation process. And fifth one is liquidation process amendment. whatever we do there, then we put this recording the YouTube also. And if you want to have a relook on it, you can move to the YouTube and go through the webinars in totality again. Okay, before we start, let me take 1 or 2 minutes for sharing with you IPA contribution, because many a time a lot of new people are there. We held our last meeting on Section 245 of the Companies Act as on 18 February 2026. Today meeting is 82nd meeting, with our membership strength now reaching to 322, and our drive of 100 rupees per member is ending on 31st March 2026. If anybody, any acquaintant want to be a member there, he can join with this reduced contribution also. What we have done, although we are in the field for more than 8 years now, for the last 6 months, what we have contributed to the profession: regular WhatsApp update, membership drive, already told, 7.5 year among, we want to cover IBC amendment bill also whenever it is passed by the parliament. Expectedly, it is to be passed in this week. I would like to share that I received one email from IIIPIA relating to the publications by them, and I found them very useful. I'm just sharing it with you, if so that these are the publication by Institute of Chartered Accountant of India. They have insolvency committee there, insolvency evaluation committee there, and they wrote books for the help of we practicing professionals. I thought of sharing it with you. This link I will be sharing you in the chat box. तो आप इस लिंक को अपने पास रख लेना, जब भी आप whenever you feel anything, look, you want to go deep into any process aspect of the IBC when running your cases, I think that they can help you a lot. I also found one thing very interesting, that seventh batch of PGIP postgraduate insolvency professionals from IICA, they have just come out with some advertisement that some pass out candidates want internship. And if any of us want to recruit any of them, this is the link I have given them, and phone number and all this in there. Go and look for them if this suits your organization as an intern. Yeah, another concern which I've been receiving from my colleagues is that, we have two categories of person, practicing professionals here. One is that who are having a lot of work, or having reasonably good work also. But there are many insolvency professionals who are dominating in number, around 3,000 in total, that they hardly have one assignment, or they don't have any assignment. In that case, they feel a lot of burden in maintaining the AFA. And now this burden has increased more also, now, because they have now said that during this financial year, you need to have attendance, CPR's attendance in physical form also. And each physical meeting is costing to them 5,000-10,000 rupees. That I think that is a little bit of concern. We as an IPA association, I pray and wish that these meetings be held, especially for new qualified insolvency professionals, at a reduced rate, so that maximum attendance is there. This is my, statutory disclaimer. Whatever we are discussing here today, that is only meant for knowledge, nothing more than that. And whenever you want to use it as per your discretion. No responsibility of IPA or any of his speaker. I think you understand this. Thank you very much.
That's nice, Manojji. So we can now move on to the session.
Yeah, discussion paper on strengthening COC oversights and procedure clarity under CIRP regulation 2016. This is our, topic of the day. Last date of submission is 10th March 2026. There are four proposals. One first proposal is strengthening recording of COC deliberation while approving resolution plan. Proposal number two is rationalization of framework for approval of CRP costs and decision making on continuation of operations of the corporate debtor as a going concern. Proposal three, clarification of the role of COC in respect of delayed claims. Exclusion of word related when COC consists of operational characters only. This is a proposal number four. But we shall deliberate a lot on proposal number two and proposal number three, whereas, a lot of new things are being brought as far as CIP cost is concerned. It is estimation, it is projection, it is comparison with the actual, it is the explanation to the COC. It is basically, initial 30 days when there was a vacuum for that, key for initial 30 days, what it will be done, that we'll be discussing. And for each of the proposal, when I conclude my proposal, I shall request my panelists and other audience also to, put their perspective also in that. What is that? In Regulation 39, in Sub-Regulation 3, for clause B, the following clause shall be substituted, namely, record its deliberation on the feasibility and viability of each resolution, the expected recovery for creditors in comparison with the fair value and liquidation value determined under Regulation 35, the adequacy of market discovery undertaking during the corporate insolvency resolution process, including where applicable, the use of a challenge mechanism or re-invitation of plans, and the capability and credibility of the resolution applicant and the certainty of implementation of the resolution plan. Now, let me, come out discussion on this thing there. The feasibility and viability of each resolution plan. Why, what is the logic of bringing this particular thing new into it rather than it was already there? Actually, I give you a practical example for that. What was happening was that in the case of let's talk, this particular aspect has been added because of home buyers cases. Home buyers cases are maximum in the NCR of Delhi and mainly handled by the Delhi NCLT benches. What was happening was that, I just give you, in the case of land developing agencies like Noida, Greater Noida, this Gurgaon in our area, in your area, maybe Hyderabad also, in Punjab, the Punjab Development Authority is also there. What they were doing that their dues after Sony's case was treated as a secured creditor. But as far as Section 53 of our water mechanism was concerned, we were earlier treating them as the operational creditors. Whenever we need to run that particular home buyers project, we need to have a license from them. And whenever we, go for the license for the construction of our project, they always says कि हमारे पहले dues clear करो. जब तक आप हमारे ड्यूज क्लियर नहीं करोगे तो हम लोग आपको आगे करेंगे नहीं. तो as a result of it, it was found that the whole plan get jeopardized. Now, just to cover up that thing there, with the feedback which IBBI got from them, now they have made it that the feasibility and viability of each resolution plan, considering such type of lacunas in the plan, should also be discussed. And what was happening was that in the case of the Greater Noida authorities and all this thing there, they were, their liability was coming out to be such a huge that creditors, even financial creditors were, not able to get much money. They were simply saying, you clear our dues, we are not concerned with your IBC, and you clear our land dues, otherwise we are going to cancel your lease amount there. As a result of which, now, and the whole plan was being jeopardized. Although it was mentioned in the IM or not mentioned in the IM, that we shall see later on. But that is, that situation was there. And at the same time, expected recovery of the creditors in comparison with the fair value and liquidation value determined under Regulation 35. Recovery to them was there. Now, this IBB has come out there that whatever discussion COC now take regarding these four aspects, it should be recorded and it should be, minutized also, so that whosoever is a SRA, he should also understand along with information memorandum also. The capability and credibility of the registered applicant and the certainty of implementation of the registration plan, including availability of funds. Another thing, they found therein was that, uh, you know, as happened that जो भी highest bidder होता H1 होता था, they used to they treat them as from PRA2, they treat them as a successful resident applicant. But IBBI found later on that many a times it was found that SRA, he has given the projections कि मैं इतने पैसे दे दूंगा, इस तरह से दे दूंगा, but later on he is not able to fulfill his commitment related to the repayment plan, and things get involved in between. अब आप उसको निकाल भी नहीं सकते, वो पैसे आपको दे नहीं रहा, एज अ रिजल्ट ऑफ विच आपका प्रोजेक्ट जो है इम्प्लीमेंट नहीं हो पा रहा, देन ही स्टार्ट asking for this thing extension and all this thing there. So now IBB has made it mandatory that whenever there is a plan approval, COC will discuss the capability and credibility of the resident applicant and certainty of implementation of the registration plan, including availability of funds with him. Although now you will say that it is already, this qualitative factor is already made part of the evaluation matrix, but there we, what are the cases I have done? In that case, it was being awarded only 5 marks or 10 marks against the 100 marks there. But the IBBI thought it's a very, very material, and it need to be, considered by the COC and be recorded there also. Along with that, one more new thing has come out to be there is that the expected recovery for creditors in comparison with the fair value and liquidation value determined under Regulation 35. Here when we shall discuss about the valuation, there we shall deal it in detail. One new concept of enterprise value has also come out to be there. What do you mean by enterprise value? That I'll let you, we shall deal it in detail when we shall discuss the valuation spec. I just closed on this particular slide, and I request my co-panelists that they should come out with their experience related to these four prisons. Anil ji, welcome, sir.
Thank you very much. Thank you, Manoj ji. Namaste, Mamta ji.
Welcome, Anil ji.
Very well, good.
Nipun ji, you can take this forward.
Yes, ma'am. So first of all, thank you, Aifa, Mamta ma'am, and Anil ji for calling me here. It's always a pleasure to be with all the stalwarts of the profession. And the topic today, which we are discussing, is actually of very much importance for all of us. And some of the deliberation, I think, have become because of some judicial pronouncements also. So I'll try to support it somewhere from the logics which I have handling the cases. So the first thing is with regard to this Regulation 39, as Manoj has already said, now the feasibility and viability was already there. In fact, what is happening is that now the courts were insisting. In fact, I can tell about my experience in NCLT Mumbai, NCLT Ahmedabad. What was happening, court was saying, how do you assess the feasibility and viability? Give us some parameters. So in fact, today also there was one matter where one broking company, a company which was an NBFC and also doing broking business, they are acquiring one textile company. So court said that how do you justify? Suppose they acquire also, whether they will be doing business or not, whether it will be going concern or not, whether they have relatable experience or not. So these parameters are now being seen by the court. In fact, interestingly, one matter when the plan was approved, it is rejected by NCLT and now also confirmed by NCLAT on the sole ground that the RA who is coming, he does not have any experience, not the same line of business. And therefore, even when a plan was approved, the company is sent to liquidation. And they have assessed that there are good amount of receivables which have not been considered in valuation, not by the PRA also, not by the COC, and therefore it should go for liquidation. So what I understand is this regulation somewhat tries to keep a check and balance on how the RAs are coming, whether the RAs are just for buying the company and not doing the business. So they are trying to, in a way, stop the shell companies which are being bought through insolvency process. Secondly, this particular issue of availability of funds, this is also now being asked by many benches. They are asking that suppose the person who is giving a bid, whether that particular person is having sufficient funds or not. So now one more thing has started, that is they are asking for either a letter of comfort or they are asking some type of guarantee or fixed deposit. So suppose I am bringing a plan of, let's say, 50 crores. So they are saying that do I have the 50 crores in liquid to make the payment, or how I will make the payment? So that is some new things which are coming up. But I found this particular thing interesting where they are saying that now challenge mechanism should be used. So we already have that tiebreaker concept, but now they have put in a way challenge mechanism. In a way, they are now saying do it by way of market driven pricing. So what normally happens in IPO, the book building process. So I think something like this they are going to introduce, that how a minimum price in the market that particular company can fetch. So these are, sir, my views. Mamta ma'am, please.
You are mute, Mamta ji.
Actually, you're quite right. And we are also, I mean, every day we are going through it because COC के minutes में कई बार लिखता है after deliberations the same has been approved, or after deliberations on the feasibility and viability, this stands approved. So I think this is trying to say that much is not enough. See, if we see the entire COC deliberation paper that has been built up by the IBBI, it is actually trying to reduce litigations because sometimes the decisions looks very opaque if it is just a single line decision. So I think so one side of the thing that could be that if too many lines are written, then people will read those lines and have their own set of litigations because हर word का मतलब निकल जाता है अलग तरीके से भी. But then still, I feel that there will be a lot of art which has been now reposed on the shoulders of the RP, that how beautifully that RP can actually capture the deliberations and put it across in the COC minutes. So COC minutes has really taken a center stage. And if you ask me, I say that I hail these changes, and I feel that it will give rise to more transparency and governance. So let's move forward to also hear Anilji. What is Anilji's take, Anil Goyalji's take on this? Mr.
So,
Shan.
Mamta ji, do I have to say on this particular slide or even overall the discussion paper?
No, why not? You can just talk about the discussion paper.
No, I think the larger and important part for insolvency professionals to understand is the changes that they are proposing now in Regulation 31 capital B.
सर उसको मैंने आगे लिया है, अभी हम सेक्शन को लेके ही डेलिब्रेट कर रहे थे.
So in case we have to just discuss about this, so I think everyone has said the same thing, that deliberation and recording in the minutes of the meeting is more important. And also they have given a kind of guidelines to RP and to the COC that what all issues that you must discuss and deliberate. And the first and most important is that the comparison between the fair value and the liquidation value and whatever your recovery, that is one issue that has to be recorded. The second important part is that they would rather deliberate and they would actually ask you to mention in the minutes whether any challenge mechanism was conducted or whether any effort was in fact made to re-invite the resolution plans or it was done hurriedly. So that is what is they want to develop the understanding whether the process was conducted for maximization of the value for the creditors or not. As far as the capability and credibility is concerned, of course, some documents were required, and this is all very regular that these questions are being asked by the adjudicating authority, and we are very particular that we normally take along with us or we submit along with us all these issues. But however, this new thing that we have to compare in the minutes that what is the comparison between the liquidation value, fair value, and the amount which is being realized. Feasibility and viability was earlier there. Manoj ji might have said, but even if I say, I agree what Manoj ji has said, but technically, in case authority, Noida Authority, Greater Noida Authority, in case the Supreme Court has actually held them as secured creditor, and for the sake of only feasibility and viability, in case a resolution plan offers a secured creditor 100% amount and to other secured creditors, for example, 40% amount, I don't think for the sake of feasibility and viability, it would be acceptable to the adjudicating authority. See, I think, Nipun, like if in a resolution plan, there are 4 secured creditors, one secured creditor is an authority, which is actually a land authority of the state, and the other secured creditors are from the lenders. Now, the resolution applicant says that I will offer 100% amount, which will be demanded by the land authority, including interest, including whatever they have. Otherwise, the resolution plan will not be implementable. And to the other lenders, he would offer, say, 30, 40, 50%. How does it become compliant to law? Because as I understand, Section 30, subsection 4 say the creditors, the COC, may distribute the resolution plan proceeds while considering the value of the security interest and also the priority of the charges. But the word used there is may. COC can still approve higher amount to one and the lower amount to others. That is what is my take. What is your take on this, Nipun?
Sir, I think there were 2-3 issues like this which were in different matters. Like the first one which went till Supreme Court was SR Steel. And since I was part of that matter, I can tell you the litigation, but it was not clearly answered. So Standard Chartered Bank and State Bank of India, both were secured creditors. But the recovery of State Bank of India and others was somewhere around 91%. As far as Standard Chartered Bank was there, it was some 1.7% only. Now, how did this happen? Because COC segregated the amount like this, that the recovery of SBI and others was more and Standard Chartered Bank was less. The logic which was given by the COC was that the security quality is also something which has to be seen. Now, the security was of mortgage asset for SBI, and for Standard Chartered Bank, it was pledging of shares. So they said that if suppose we sell our mortgage assets, the value of the shares will go down. So that pledging of shares value has no value if the original assets in the company goes away. So the court accepted this argument and the recovery was less, even though the plan was approved, even though the category of secured financial creditor was the same. Inside that category also, there was a differential treatment of 2 financial creditors. Now, the similar...
that is not a differential treatment. No, what exactly the COC argued before the adjudicating authority, that the value of the security of one bank who actually have shares only is lesser because of the marketability, because of various other quality of the security, because the value was lesser. Now the question is, as I said, Section 30, subsection 4 says the COC may distribute the proceeds of resolution plan according to the value of the security interest and the priority of charges. In case the value is less, so that means the lower distribution is justified. And in case the value is more, it has to be higher. Now, in case of authority, land development authorities, even if the value of the security is less, but they are still asking that you give us the interest up to date, you give us the damages up to date, and you will give us the compounded interest up to the date of payment, then only we will allow you implementation of the resolution plan. Just only because of the implementation, because of the feasibility and viability of the implementation, can we actually distribute the proceeds of resolution plan with so much of difference? So that is the question, which is not purely based on the value of security interest. It is over and above the value of security interest.
I was trying to say this, that even if both the creditors are equally placed, even then a differential treatment is permitted.
Yes.
So it is ultimately dependent on the wisdom of the COC. How do they inter alia divide it? And you are right that suppose there is one of the creditor, if without satisfying that particular creditor, the plan itself will become non-viable. So if suppose the, let's say, Noida authority or some authority which has the land, and that's the only asset of the company on which the plant is relied upon. So probably I think that Prabjit Singh judgment, wherein the plan was set aside and again sent back to the COC on only this ground, that the Noida authority's claim was not there and they have considered that property, which is actually the property of that authority, plan cannot work out. So I think in that case, collective bargain will have to happen. And probably some of the creditors will have an upper hand, because if that creditor is not satisfied, the plan will also go away. So my view is yes, there would be some cases where one of the creditor will have an upper hand to negotiate. Yes, whether that will.
Mamta ji, what we are doing for the purpose of real estate cases.
Yes, yes.
Let us understand the landowners who have actually entered into a collaboration agreement with the builder. Now, in case we don't offer anything to that landowner because he has not submitted any claim, we have only mentioned in the IM that this person actually, as per the collaboration agreement, he actually is entitled to say 40% of the constructed space.
Right.
Now, the landowners are not submitting their claim. They are saying that I have the power to cancel the collaboration agreement, so he can cancel. So that means that is also a difficulty on feasibility and viability. So what we are doing, we are separately negotiating with the landowner that instead of 40, because the assets are lesser, you can accept say 27, 30%, and then we are making it a kind of a condition in the RFRP that anyone, so we, with the permission of the landowner, that anyone who actually will offer minimum offer to the landowners will have to be say 27 or 30% instead of 40%. So that is also resolution amount being offered to a person who has not even submitted their claim. It is going out of the resolution plan, but only because of the feasibility and viability, without even a claim.
Sir, let's move forward. Mamta ji, please carry on.
Yes. So let us have the next slide, Manoj ji.
इसमें मैं एक दो चीज़ें और ऐड करना चाहूँगा. जैसे मैं अनिल गोयल जी की, बिकॉज व्हाट इज हैपनिंग इज दैट कि बिकॉज ऑफ सम जोग्राफिकल रीजनिंग हमारे यहाँ पे एनसीआर में होम बायर्स के केसेस बहुत ज़्यादा हो रहे हैं, तो वी पीपल आर हैविली इन्वॉल्व इन इट. जैसे सर ने अनिल जी ने कहा, मैं इनकी बात को थोड़ा सा और एक्सटेंड करते हुए बात करूँगा. Many a times, lessons is in the name of the landowners. And when we as a home buyer try to complete the project, तो वो having a lessons with him, he always have a dominating hand. एक बात. दूसरी मैं इसके अंदर एक बात और ऐड करना चाहूँगा, जो हमारा ये डिस्कशन पेपर है. आई जस्ट कम आउट विद माई दिस स्लाइड देयर अगेन, क्योंकि ये हमारा डिस्कशन पेपर है, इसके अंदर हम अपनी इनपुट है वो भी दे सकते हैं. आज की डेट में सिंस IBBI was also concerned with expected recovery for creditors in comparison with the fair value and liquidation value. But here we जो अभी हम आने वाले स्लाइड्स के अंदर आगे हम देखेंगे कि एक नया कंसेप्ट ये वैल्यूएशन के अंदर इन्होंने अमेंडमेंट में लाया है, एंटरप्राइज वैल्यू आल्सो. In my opinion, I think that should also be a word added there, that the comparison should not be with reference to fair value and liquidation value, but also with reference to the enterprise value also. What do we mean by enterprise value? जैसे हमने आपको पहले कहा, जैसे हमारा valuation के आएंगे तो I address you, what do you mean by the enterprise value? Sir, these are my two additions of what our expert has said. So, sir, if permitted, I move forward.
Sir, I would like to just add something on what Anil ji said.
Yes, please.
So, Anil ji gave that example that whether there is a landowner and we are negotiating with them, he's also a third party. Sir, I have handled two such cases, and there are some judgments, obviously, on the facts of the case, which have been confirmed by NCLAT also. What they say is that suppose somebody is a landowner and he has done a joint development with the corporate debtor who just had the development rights. So there is no land with the CD. CD only has development rights, and there is a landowner. Now, whether that landowner during this CIRP process is entitled to become a part of the COC by filing a claim, or whether he will stand outside. So the claim, which if it all is filed by the landowner, whether it will be taken as a financial creditor, or he will be standing outside and trying to say, no, I would terminate this particular agreement itself with the CD. So there are few cases. One is this Ashoka Buildtech case of NCLT. Originally, it emanated from NCLT Indore. And one is NCLT Mumbai case, which went to NCLAT, that is Namdev case. Both these judgment, the view taken by the NCLAT was that, see, once you are become a partner with the CD, you cannot say that I am not interested in this project. You will have to file a claim. Your claim will be treated as a creditor, whether you are a financial creditor or another creditor, that will be decided on the terms of that particular agreement. So yes, a negotiation can be there, but whether they will be in the COC or outside the COC, that is something which is dependent on fact of the case. Second thing, sir, in similar case, we have also got some orders where the denial was by the landowner saying that I will not do the sale deed. CD, I have already paid as a home buyer. Now there is a dispute between CD and the landowner,
अरे
and
उधर
now
ठक
the
ठक की शुरू
company
करती
is
बंद करो उसको मत
Manoj
ठको
sir.
ऊपर
Manoj sir, your mic is on, sir. So in one case where the home buyer has completely paid the money to the CD, CD had to do the sale deed. But the sale deed has to be a tripartite agreement. Landowner has to also sign the agreement. Now landowner says that you are under insolvency. I am not going to get anything. So I am not going to sign it. So courts have ordered, and that's what now it is captured in the regulation also, which came last year, that the sale deed has to be done by the landowner if suppose there is a dispute between landowner and the CD with regard to his share of profit from this home buyer's payment. It is a claim only on the CD. They cannot deny the execution of sale deed. So this is what I just wanted to share, because some of the cases which we have got some orders, this is the position, sir.
Yeah, I also agree to what you say, because otherwise the whole fabric of CRP, etc., the whole fabric of insolvency resolution process will get disturbed. अगर आप ये देखेंगे कि इनके बिना हमारा काम नहीं चलता है, and we start giving it to him or her or it, and जिसके बिना काम चल जाएगा, so that means you're distinguishing even amongst the same placed creditors. So, that will be very perturbing. Anyway, Manoj ji? We have quite a
My last question is that we
Manoj ji,
move forward.
we have lot of ground to cover.
In the coming bill, they're proposed to be treated as not as secured financial creditors, these landowning agencies, because now they're coming out with a proposal that where security interest is not created voluntarily, they won't be treated there. Will that make any difference? Anil ji, small answer to that from your side, and then move forward, please. I think Anil ji is not there.
No,
Anil ji?
I'm definitely I'm there, sir. I'm sorry.
Yes, sir. Please. You heard my question?
No, I could. Sorry.
I repeat it again that in the proposed amendment bill IBC, which is expected to be placed before the Parliament in this week, these secured creditors, basically Greater Northern Authority and other authorities, are not going to be treated as a secured financial creditor. They be treated as even only operational creditors. Because the amendment is very clearly making distinction between security interest created voluntarily or otherwise, because by operation of law, and they become secured by operation of law. Will that amendment affect the coming process which you just discussed related to home buyers?
Manoj, there are two parts of this security interest that the Supreme Court is talking about in the case of Prabjeet Singh Soni. In this particular judgment, the Supreme Court has relied upon the Act of Authority, Noida Authority, where it is based on the Act. It is the charge which is already created on the land. So that is one part. But secondly, in case you see the agreement, which is normally signed by the authority as well as the builder, in that agreement also there are clauses which says that the authority will have lien in case there are dues or in case there are lease premium which is outstanding. So in the Prabjeet Singh Soni judgment, the Supreme Court actually decided based on that law which is in the Uttar Pradesh government.
Greater Noida Authority.
Greater Noida Authority. But in case you go through the agreement which is signed by the corporate debtor or the builder and the authority, you will find clauses which will be considered that there is an agreement which is signed by both the parties and there is a lien which has already been created. So it will not be very clear to say that in future, once the amendment bill becomes the act, they will not be considered as a secured creditor because they will find clauses in their agreement which will still entitle them to become secured creditor.
Okay. Thank you very much. Let's move forward. Rationalization of the framework for approval of CRP costs and decision making on continuation of operations of the corporate debtor as a going concern. Sir, ये वाली जो proposal है, ये it is going to affect a lot to everybody here. Hence, I just give you the background. What basically what in fact this background is I've taken from the paper only, discussion paper only. The Insolvency and Bankruptcy Code 2016 aims at value maximization through a time-bound and creditor-driven resolution process. However, during the initial phase of the corporate insolvency resolution process, the Committee of Creditors is not constituted as creating a regulatory gap where the interim resolution professional must incur costs without prior creditor approval. While sections 20 and section 25 of the IBC require the IRP and RP to preserve the value of the corporate debtor and maintain it as a going concern, continuation of operations has been sometimes occurred without structured financial assessment. This has led in certain cases to unnecessary cost escalation, inefficient resource utilization, and erosion of enterprise value. Additionally, decisions regarding operational continuation and CRP costs are occasionally taken without documented financial analysis or early COC oversight. Therefore, there is a need for a financial ensuring that continuation of operation and CRP costs are guided by the commercial viability, financial assessment, and effective creditor supervision. इसके साथ एक चीज one thing I would like to add also there that many a time this 30-day period extends a lot. Whereas practically I'll let you know, whereas NCLAT does not allow functioning of the COC, but at the same time they allow the appointment of the RP. At that time, RP is doing limited duty. In that case also, he says ki, whatever prescribed fees is there, that should be paid to me. Company operations are running out in a usual manner there, and it depends upon a lot of it depends on the NCLAT's orders that how much responsibility they give to the RP and whether they allow constitutional COC or not. तो हम जब इसको CRP cost के बारे में discuss करेंगे, we shall take these two things also into consideration. And at the same time, they are coming out with approval and all those things there. But at the same time, it is very painstaking for we people also. Reason for that is there, whatever approval we require from the COC. COC mainly consists of banks. We deal a lot with the State Bank of India. They take a lot of time in approval. Now they are saying that there should be a estimation, projection, and then actual, and then difference and all this in there. Then, can we expect that with a timeline of 180 or 270 days, such approval will be there? I would like my panelists to be prepared to deliberate on that also. Let me go through the point once again, what this particular section says. Regulation 31B has been added, which says the insolvency professional may incur insolvency resolution process costs for a period commencing from the insolvency commencement date up to 30 days from such date, or the date of constitution of the Committee of Creditors, whichever is COC हम constitute करते हैं वो within 30 days ही होती है. Basically, what happened is that when we issue public notice, we are supposed to issue within 3 days. Then after that, we need to give them 14 days time for giving their claims. Then we are 14 plus 3, 17 days. Then 7 days time is given to us for this thing for for approval of for verification of their claims. 21 days is passed. Then 2 days is also given for filing with the NCLT and all this thing there. So that is there. The insolvency resolution process costs incurred under sub-regulation 1 shall be
So I
limited
think,
to.
Manojji, we need a discussion on the very first point.
Okay.
And one that is discussion, what is written here is because I think we may have to give some feedback also.
Yes,
So
yes.
the cost for a period commencing from the ICD to 30 days, I think you can keep that particular slide on. I would have to say whichever is earlier.
Yes.
So whichever is earlier means that one, it should not be more than 30 days. Number two, if the COC is constituted on 21st or 22nd day, then only till that day the IRP can incur costs, and thereafter it is not possible to incur cost later on. So that means there are two things that we actually have to say. In case there is any stay on the constitution of the Committee of Creditors, then the RP only can incur the expenditure up to 30 days, not beyond that, whichever is earlier written, if I'm not misunderstanding.
Yes.
And the stay continues for years, at times months and years, and then the operations also continue for that period, and RP continues in his position as RP, and he is duty bound to supervise the operations. So that is what is a concern. Whichever is earlier actually is restricting the operations during stay. So this is something that the feedback should go.
Yes, exactly. I agree with you. Any dissenting view, and otherwise we move forward. Okay. The insolvency resolution process cost, we should dissent with it. This is our unanimous opinion coming out to be there, but subject to your discussion. The insolvency resolution process incurred under sub-regulation 1 shall be limited to costs necessary for preservation and protection of the assets of the corporate debtor, meaning thereby, a simple language, if you try to understand, security services, maintenance of essential services. That is, that is already being there. In any case, compliance with applicable laws and statutory requirement, meaning thereby appointment of advocates. Such minimal operations as are necessary to prevent value deterioration of the corporate debtor. In one of the discussion, what I was having with one of the senior RP, he was saying कि मैं तो भैया wherever I go for an appointment, I always said that till approval of my cost by the COC, all money has to be paid by the applicant. But that is a out of tool the thought process. Generally, it doesn't happen. I said the NCLT orders for 2, 3, 5 lakh rupees based on the size of the case
I
to be
think
paid by the applicant.
he has never seen applicant like PNB, State Bank of India, or any other financial creditor. Has he dealt with them? Like, as far as this paying everything by applicant, I don't think it is really.
Yeah, that is that side. It is out of the box suggestion from his side. But let that thought be given to our insolvency professionals. If they can manage, they can get it. Yes, sir. तो अब इसके अंदर जो मेरा कंसर्न है डी सब क्लॉज पे सच मिनिमल प्रेशर एज आर नेसेसरी टू प्रिवेंट वैल्यू डेटरेशन ऑफ द कॉर्पोरेट डेटर विल दिस टाइप ऑफ लैंग्वेज नॉट go for litigation and all this thing there, and how we as an insolvency professional shall treat this particular clause for our running of the process.
Should I?
Yes. That
Yes, I thought Anilji is taking. Yes. So I think, sir, this clause D definitely is going to create litigation. In fact, sir, I don't recollect the name of the company, but there was some type of a minimum guaranteed protection which has to be done. If you don't do it, you will be facing cost from the authority which had given that contract to the CD. once insolvency was admitted, if they do not produce that much units of that particular material, then there was a cost. So I think this is going to be a very catchy clause. To prevent value deterioration means अगर लॉस 100 रुपए का होने वाला है और अगर आपने बंद कर दिया उससे लॉस 150 हो गया, तो आई थिंक दैट इज गोइंग टू बी अ वेरी ट्रिकी सिचुएशन. बट
अनिल
सर
जी.
जो जो अनिल जी ने बोला था द फर्स्ट वन द सब रेगुलेशन वन, आई थिंक सर वो बहुत ट्रिकी है because I have seen cases and in fact normally what happens is in case of section 9 immediately the promoters move the NCLAT and get a stay. Up when there is a stay you can't call the COC और उस केस में you have to do the all these compliances and they don't also remove the IRP. They say IRP will continue but no COC meeting shall be taken place. No further steps to be taken by the IRP. Now, in this particular situation, I don't know how this clause will be considered by that IRP. Anil ji,
May I
please.
ask one question, please?
Yes,
Yes,
sir. Yes, yes, Shantanu ji, please.
तो मुझे ये है because of this thing. Let's say within the first 30 days, you come to a conclusion that the promoters have been carrying a lot of employees. बहुत से टाइम ऐसे होते हैं, पैसे तो देते नहीं है but they have not laid off the employees and इनके पैसे becomes due, right? And अगर आपने एज ए IRP डिसाइड किया कि वायबल नहीं है और जो आपको कह भी रहा है कि यू हैव टू डिसाइड व्हाट इज वायबल व्हाट इज नॉट वायबल, और आपने डिसाइड कर लिया कि इसको ले ऑफ करना है या बंद करना है, आप वो डिसीजन ले लेते हो, अब उसमें तो इमीडिएटली इनके ड्यूज पेएबल हो जाएंगे इन ए वे. तो हु विल पे? पैसे तो ऐसे भी है नहीं, प्रोमोटर्स आर कैरिंग मेनी थिंग्स और वो लोग मैनेज भी करते हैं इन वॉट एवर स्टाइल, लेट अस नॉट गो इनटू दैट. इसको फिर आरपी के ऊपर तो इतना लायबिलिटी आ जाएगा, आरपी के ऊपर इतना लायबिलिटी आ जाएगा, मतलब दोनों बाजू से लिटिगेशन होगा. एंड देयर इज नो दे आर टॉकिंग अबाउट सीओसी ओवरसाइट, दे आर नॉट एट ऑल टॉकिंग अबाउट सीओसी ऑब्लिगेशन टू गिव फंड्स. ये कौन बोलेगा? एक बार एज ए एसोसिएशन मे बी वी शुड पुट इट डाउन लाइक दिस. नहीं तो अगर ऐसे केसेस में जहां स्टे आ जाता है तो एन आईआरपी इज टोल्ड टू बी कंटिन्यूड, आईआरपी के पास क्या रहेगा कि अदर देन रिजाइनिंग?
Sir, I just shared one
मैं तो रिजाइन
practical.
कर दूंगा, ऐसे
नहीं
कोई
नहीं.
केस आएगा तो मैं तो सीधा मुंह पे
Now,
रिजाइन कर दूंगा.
I would try to answer the solution for this because see, there are many unclear judgments that the RP will continue, but the RP will allow the KMPs to run the company. RP will allow the KMPs to operate their bank accounts. So that is when there is a stay. So this definition of stay, when this committee is not constituted, so there are two kinds of stay, Shantanu. One is that the stay on the constitution of Committee of Creditor.
That is what is happening most of the time.
And most of the time this is happening. And the second also that the no further steps would be taken by the RP.
Absolutely.
Or IRP. This is that the two kind of so in this first kind where the no COC would be constituted, that actually means that the RP will continue to receive claims, will continue to verify, will continue to do all compliances, but only thing which is which requires the approval of the Committee of Creditors would not be conducted. So I believe what we should recommend to IBBI on this particular, that instead of this whichever is earlier, it should be clarified so that otherwise it will actually be reaching to a chaos. Now, second, when this RP is not supposed to take any further action, that is little more stringent stay. In that case, in the case of some Ashok Tyagi, the NCLAT has actually clarified that these KMPs will continue, RP will also continue, KMPs will run the operations, and the KMPs will operate the bank account under the supervision of the RP. RP has only a right to monitor it, not exactly operate the bank account in case the RP is told not to take any further steps. So when in these two situations, the IBBI should clarify how the cost would be approved, how it will be supervised.
Yes, sir. Because in my case, in my current case, there is a stay in COC, no further steps to be taken. So I went to NCLAT saying, ki, boss, does the company go back to the management? Well, I was pretty happy, frankly, to give it back. But they said, no. We are not saying that moratorium will be lifted. Moratorium runs, you do all the compliances. Now, who the hell is going to pay for it? And nowhere is it written that the promoters are also supposed to cooperate with me. They are supposed to do anything. You have to do all the compliances. So now,
yeah, sir, let's move forward bit because we already.
तो इसको बताइए, इसको कैसा solution है? ये तो suicide है. ये जो लिख रहा है.
As I said, we should give a recommendation, suggestions to IBBI, whichever is earlier part. That has to be.
That is 100%, sir. That is 100%. It is still the constitution of COC होना चाहिए.
And
that is,
once that is resolved, then the sub regulation 2 also gets resolved.
चलिए, तो consensus ये बन रहा है कि we should recommend to the this thing to the IBBI that till the constitution of COC, not 30 days there. And as far as clause 2, clause D is concerned, minimum of operation, that is quite subjective. We need to delve into case by case basis. फिर भी अगर आप लोगों को ज़्यादा difficulty किसी को आए, किसी को, मेरे को भी एक case मिला था. I remember one of the very big case where ultimately Supreme Court quashed my appointment. Daily expenses are very huge. Chaliye, let's move forward now. I'll be a little bit quick now because we hardly cover 10% of our work only.
Actually, and we are quite.
Yeah. No, actually, this was the timeline. I just passed on there. I've already spoken for the constitution there. Okay. Rationalization of the framework for approval of CRP costs and decision making on continuation of operations of the corporate debtor as a going concern. Proposal 2. All insolvency resolution process costs incurred under clause 1 shall be placed before the committee at its first meeting for approval, together with the justification of such costs. At the first meeting of the committee, the insolvency profession shall place a going concern assessment report, including estimated income, expenditure, and cash flows arising from continuation of operation, details of working capital requirement, if any, and materials risk of value erosion arising from continuation or suspension of operations. Based on the going concern assessment report placed under sub-regulation 4, the committee shall decide whether the operation of the corporate debtor shall be continued, and if so, the scope and duration of such operations. Sir, allow me to speak a little bit briefly. It is happening with all of my IP brothers also. Whenever any case comes out to be your office now, पहले 30 दिन के अंदर जो इतना काम होता है इंक्लूडिंग पब्लिकेशन, वेरिफिकेशन ऑफ क्लेम, कॉन्स्टिट्यूशन ऑफ COC, मन में तो यही धड़कन लगी रहती है सबसे ज़्यादा कि वेदर फ्रॉम IRP से हम RP बनेंगे या नहीं बनेंगे. Although whosoever has appointed you as an IRP, because when you start constituting COC, a lot of new things come out to be there. Then you need to lobbying them or to put your credentials before them. इसके साथ इतना सारा काम करना, it will be these are what estimation of income. अरे भाई, मेरे को आज की डेट में कोई बंदा ये कह दे कि एक नेशनल टेक्सटाइल कॉर्पोरेशन की में जाके आप उसकी एस्टिमेशन ऑफ इनकम कर लीजिए, वेयर दे हैव 150 फैक्ट्रीज देयर. आई कांट डू इट. If how much I can rely on the CD also. What in nutshell I mean to say is that doing so much work in the initial 30 days is a hurricane's toss. Briefly, Anilji and Shantanu ji or maybe Nipunji, what is your assessment? And as far as preparation of this going concern assessment report by COC within 30 days, in my opinion, Mamta ji, you also give your opinion. It's a very, very hurricane's toss to do it within such a short span of time. Please, short comments by everybody.
नहीं हो पाएगा सर, ये वेरी शॉर्ट कमेंट, नहीं हो पाएगा. यू आर वेरी राइट. अनलेस इट्स अ वेरी स्मॉल सा कंपनी, वो भी कुछ है
उसमें
नहीं,
आपको डाटा नहीं मिलेगा. अगर
डेटा नहीं मिलेगा,
डाटा नहीं मिलेगा, फिर क्या करोगे आप?
डेटा नहीं मिलेगा,
वही
डेटा
सबसे
नहीं
बड़ा
मिलेगा.
बात है, डेटा ही
सर,
नहीं.
आपका डिस्क्लेमर दोगे? What I mean to say is that we respectfully submit to the IBBI that let this proposal be dropped, be impracticable. Sir, बाकी लोगों के comments.
No, I think this is something which actually will cause a lot of work for IRP and the RPs, and this is a huge work, because see, it is not all the RPs are chartered accountants. So when the RP is supposed to make income estimates, expenditure estimates, cash flow estimates, and that too from each COC to the next EOC, then comparing the estimates with the actuals, that is completely running the business. And like, I don't think every RP is equipped. So therefore, the immediately the RP will say that we need to, in fact, engage an experienced chartered accountants for doing all this, and this will increase the CIRP cost. So in case the operations are going on, and if this is the requirement, then the COC, what my understanding is that the COC, whenever it comes to financial approvals, even if it is for 20,000 rupees, 50,000 rupees, the COC will not approve it. The COC will say, you put it on voting. So when we actually present a expenditure estimate of for 10 lakhs a month, or even 10 crores a month, they will never approve it in the meeting itself. They will say, they will say, put it on voting. And normally for such matters, they will take 15, 20 days. And by that time, the next meeting will come. So therefore, for the 20 days, for the 25 days, no probably, as per this regulation, no expenditures can be incurred in case there is not approved by the Committee of Creditors. So this is completely impracticable. That the expenditure would not be. I'm only saying only till that particular level, that the fund flow estimates of cash and income that will be presented before the Committee of Creditors for their review and for their comments. Like in case we ask for their approval, the banks, may it be public sector, may it be private sector, they will take minimum 15 days time to approve this kind of cash flow and this kind of expenditure.
Sir, I would like to add there, State Bank is the biggest stakeholder in most of the COCs. What system is there? Generally AGM level people are coming to your COC. AGM will ask DGM. He can't do anything without the permission of the DGM. And if something else is there, like if company want to go for the liquidation, if some expenditure is above limit, then they have to go above in the hierarchy to AGM to DGM, DGM to GM, GM to committee to all this thing there. And unfortunately, their committee for approval of these expenses sits once or twice, maximum once in a month, or in a 2 month. How we can run this process? This is practically impossible. Let's give submission to the IBBI that see the practicability of this thing. As we are saying, let's not this will not be brought into brought into the books. Okay. Now let me come to the clause number 6. After the first meeting of the COC, all insolvency process costs shall be incurred only with the prior approval of the committee. For the purpose of subsection 6, the RP shall at each meeting of the committee place periodic estimates of the statement of income and expenditure, cash flow statements for the period up to the next meeting, seek approval of the insolvency process costs proposed to be incurred until the next meeting, and place a statement comparing actual insolvency process costs with the estimates of the costs approved by the committee in the previous meeting. First of all, जैसा अनिल सर ने कहा, I endorse his view. Even estimation is very, very difficult. Even if you hire anybody outsider, gap between two meetings is 30 days, or at the most with the permission 3 months. Nobody can do it until unless he is industry expert. How much you can rely on the CD staff, especially if he's inclined more to the past management. So meaning thereby that these are highly impracticable, and a lot of responsibility will come on the we as a process runner. Secondly, if there is any variance, estimate and actual, then in the whole COC meeting will devote whole time in seeking explanation from the RP or IRP why this variance is coming out over there. Chaliye sir, let's move forward.
Yes, it's very
yes, please, Mamta ji,
very
please.
impracticable. Right.
Okay. Clarification of the role in respect of delayed claim. Now we have discussed CRP costs a lot, which need to be discussed, and now we come out to be there delayed claim. As far as delayed claim is concerned, what I just give you a little bit of background for that. Background is that Regulation 13, subregulation 1C and subregulation B of the CRP regulation requires the RP to place delayed claims received after the timeline under Regulation 12 before the Committee of Creditors and the adjudicating authority. However, in practice, ambiguity exists regarding the sequence and scope of such consideration, leading to the interpretation that only COC recommended delayed claim need to be placed before the adjudicating authority. The approach contradicts the settled legal position that the continuation of delay and adjudication of claims lie exclusively with the adjudicating authority, but definitely, at the base of the RP, while the COC role is limited to commercial decision making. Consequently, such delayed claims found unacceptable by the RP are not placed before the adjudicating authority due to lack of COC recommendation, resulting in procedural inconsistency and avoidable disputes in the CIRP process. So what this is there. What I explained to you is that COC has no role in approval of the claim. What practically I have seen is that since whenever any new claim comes out to be there, COC power get diluted because of admission of that new claim or maybe enhanced claim or something like that, and they are always not eager to accept the recommendation of RP to accept that claim. Number one, we have seen it in our all processes that how step treatment financial creditors, mainly banks, are giving to the operational creditors. They will have a haircut of 30-40%, but expect that operational creditor will have an haircut of 90% or above that also. So, this is a welcome move in my opinion, because COC for placing an approval of claim has been bypassed. Now let RP go directly to the adjudicating authority, and this is, I feel, a welcome move. Sir, Anil ji and Nipun ji and Mamta ji, your say on that. Then we move forward.
Yes, Anilji, please, Nipunji, Anilji, please.
No, I think this delayed claims, the primary change is that
Manoj, you can have the whole slide on the screen. It will facilitate discussion.
so the primary change is it was misunderstood that the COC has the power to reject or accept a claim. So to clarify this, they actually have said that the COC is totally independent from claim verification. The COC does not have any role in claim verification. So earlier, in the case of delayed belated claims, it was perceived that the COC has a power to reject or accept a belated claim. So now they have clarified that the COC doesn't have a power. It is only the RP has to assess it, and then it has to go to adjudicating authority. The role of the COC is not there in the acceptance or rejection of the belated claim.
Okay.
Primarily, this is the only concept.
Yeah, we should go for it's a September. Okay, sir, I have one question. If you remember, in the earlier years, 2-3 years ago, these, there was whenever any belated claim come out to be there after 90 days, something like that, then the claimant supposed to go to the NCLT and make the RP to sub that claim. Not like that. Not like otherwise that we as an RP submit the claim and then do all this in there. Do you feel that that practice was better than this one? Mamta ji and Nilesh, Nipun ji, your opinion?
I think reduction of litigation is the basic objective.
Okay,
in case we are able to reduce
this practice is better, sir. This practice is better because otherwise the litigation would go. Every delayed claim will go before the NCLT. Then they will issue a notice to the RP. Sorry, I am interrupting Anil ji. But
Shantu ji, welcome.
And then you have to engage a lawyer for every such hearing, and NCLT may take months together to even decide. So it is better RP बना के दे दे, सर आप कंडोन कर दो, खत्म करो.
चलिए, ओके, वो तो जनरली कंडोन कर ही देती है, स्पेशली
हाँ वही आरपी कर देगा तो अच्छा है. लिक्विडेशन में भी यही करना चाहिए,
कर देते हैं,
लिक्विडेशन में भी यही करना चाहिए.
चलिए सर, now these are all related to clarification of the role of COC. एक इसके अंदर बड़ी छोटी सी clarification आई है. We have a regulation section which provides for the constitution of the Committee of Creditors in cases where the corporate debtor has no financial debt or with the financial creditors or related parties. In such situations, COC
Sorry, Manoj. Sir, I think we had to discuss this also within 1 week of receipt. We had spoken कि 1 week of receipt wala we had to discuss.
Yeah, that was there. That how
Now,
I
this
think
has
that is.
got an implication, a very kind of serious implication.
Yes.
That means that the RP will file an application to adjudicating authority after every 1 week. Because in the case of home buyers, you will receive claims every week, maybe one or two, and that will continue till the entire CIRP period. So this needs to be corrected. Manojji, it is our duty to go to IBBI to get it corrected, because this will not resolve the litigation. It will actually create a lot of litigation.
My apology, I just missed that particular section. But in any case, let me. I agree with you, sir. एक हफ्ते वाला तो पॉसिबल ही नहीं है. That is practically impossible. वो उसके अंदर कैसे आप बिलेटेड क्लेम किसी का आया तो उसके अंदर कैसे आप करोगे? That is, I fully agree with you, and that is.
It's-
That is absolutely not possible. तो वो तो हमारे को I don't know where I missed that particular slide.
सर इसी में है सर, आप जो स्लाइड शेयर थी उसी में है.
उसी में है.
उसी में है सर, रेगुलेशन 13B1. यस सर.
Yes,
इसी.
yes, it is already there. Yeah, it was there. Yeah, 1 week never possible. And either my advocate friends can suggest me either they should come out of updating of that particular IA. For example, we
Now,
filed
the
one IA related to
present
claim,
regulation,
and
Manojji,
yes, sir.
present regulation is that all the belated claims that would be accepted or rejected by the RP, and then an application for condonation will be filed to adjudicating authority. However, there was a kind of in-between process that all this will be placed before the Committee of Creditors. Now, placing it before the Committee of Creditors is removed. However, we actually can say IBBI that is a better process, that when we are actually resolving a case, before the resolution plan is put to vote, 1 week before that, all the belated claims will be submitted. But then there is a difficulty. There may be a claim which is impacting on the constitution of Committee of Creditors. There may be a larger claim which is the secured creditor, unsecured financial creditor. So that actually will affect the constitution of committee. So within 1 week is primarily to avoid those kind of litigations that every week, but there has to be something by kind of, in case it is impacting the in IM, then I think before the IM is printed, this is one application. But in case it is a financial creditor impacting the COC, then it is 1 week. So it is not something which is applicable on all the belated claims. There has to be 2-3 provisos to that. One proviso
Okay.
for all those claims which is impacting substantially to the Committee of Creditors. Then it is impacting the IM. Before the IM, all the claims must be submitted. Then before the resolution plan voting. The 3 stages should be there.
Okay. As far as Anilji's suggestion is concerned, instead of 1 week, let it be split into 3 parts. During the, what are the intervening period be there? Because in our daily we are seeing that as far as plan approval is concerned, the NCLT is taking not months but years now. चलिए ठीक है सर, तो we can give that recommendation there. Okay, now let's move to it's a very simple regulation. This is a very simple proposal. What was happening was that there was a confusion that we all know in the constitution of COC, when it consists of financial creditors, related parties is excluded. But in the case when top 18 operational creditors are being considered under regulation 16, in that case there was no clarity whether related party will be there or not. As far as law is concerned, there was not there, and IBBI found that many a times OCs of related party are running the whole COC. Just to curb that particular practice, they are now coming out with the proposal to amend regulation 16 2A to insert the term unrelated as under 18 related party creditors by value, provided that if the number of such unrelated operation creditors is less than the 18, the committee shall include all such unrelated operational creditors. अब सर इसमें मेरा एक क्वेश्चन ये आता है, let's it's an hypothetical question. Let's presume that we don't have any financial creditors and all the operational creditors are related party only. In that case, IBBI should have come out with some provision in that case also. What take is from the experts?
Manoj, in case you can excuse me, I have to go for another meeting. In case you can excuse me, and I
Sir,
think
Maliko,
no,
yeah,
no, I
but
think
we
just
are we're
wanted
really
to say
thankful for
thank
your
you very
practical
much
input.
for inviting me.
No,
Thanks
sir,
a
we
lot.
are really thankful for your practical input in all this thing there. And अब इसके बाद वैसे भी वैल्यूएशन स्टार्ट होने वाला है, तो अगर अंकित है तो उसको भेज देना. He is expert in valuation.
हाँ, अंकित को पूछता हूँ, although he is also busy with me in the meeting. Then let me see.
चलिए, कोई बात नहीं, कोई बात
All
नहीं.
right. Thank you, everyone. Thanks a lot. Thank
Thank
you.
you.
Thank you, Anil ji.
So OC का it's something very clear.
Yes, sir.
Nothing need to be delved much into it. We hardly have now 35 minutes. Let's move to second
Yes.
half of our presentation. It relates to the amendment. There are 5 amendments and regulations. IBBI liquidation process amendment, voluntary liquidation process amendments, bankruptcy process amendment, CRP process amendments, प्री पैकेज इंसॉल्वेंसी अमेंडमेंट. तो इसको मैंने कोशिश करी है कि जो कॉमन टाइप की अमेंडमेंट्स हैं उनको इकट्ठा क्लब करने की. तो दैट विल कंज्यूम लेस टाइम. तो फर्स्ट ऑफ ऑल लेट मी टेक अमेंडमेंट. हियर वी डोंट हैव एनी डिस्कशन. हमारा तो इस पे अब ये अमेंडमेंट्स आ ही गई हैं, तो इसमें हमारी कोई रिकमेंडेशन है नहीं आईबीबीआई को. तो जो अमेंडमेंट्स आ गए सिर्फ हमारे को उनको समझना है. तो लेट्स गो अहेड विद दैट पर्सपेक्टिव नाउ. What valuation, these are basically amendments related to valuation only, except in the case of CRP, where some IM related amendments has come out to be there. What those amendments are, when we are running the process, we need to understand all the things there. So these are already applicable. 25th of February 2026, it was notified. Since then, it has, these amendments are applicable. Voluntary liquidation and bank, these are the common amendment for VL liquidation and bankruptcy. What is that? Yeah, all came into force with effect from 25th February 2026. What basically, I'm telling you everything from a broader perspective. Then later on we should move to the particular regulation. Now, the running process perspective, international standards now replaced with the valuation standards notified by the IBBI through circular. Uniform valuation post format registered valuer must prepare reports as per the IBBI prescribed format. Mandatory documentation maintenance has been asked by IBBI for valuers to maintain. Valuer must maintain supporting document for the valuation report. No, what those amendments in the regulation are. Those were the broader aspect of those amendments. Bankruptcy process has been amended by Regulation 30, Sub-Regulation 2. What earlier provision was that? Valuation to be done as per internationally accepted valuation standard. Now amended provision is valuation standards as notified by the board through circular. If we look into the nature of change, it is in alignment with the valuation standard with IBBI notified standard instead of the international standard. If we remember, if chartered accountants who are in this field, who are in this webinar, they be just knowing that when 2013 Act came out to be there, at that time they said that companies having a net worth of more than 500 crore rupees should convert to Ind AS. So at that time we were having two standards. One was of GAAP, generally accepted accounting practicing standard, and another was IFRS, international the standard. And government came out with Ind AS. Ind AS means clubbing these two standards, meaning thereby that standards which are applicable for international aligned to Indian, basically atmosphere. Hopefully, IBBI must be doing a lot of hard work, and they be coming out with such type of standard for valuation also. In this case, let's see. These standards are yet to be notified. Till then, we have to go with the international standards only. Now, another amendment is in the Regulation 30, whereas the new sub-regulation 30 sub-regulation 5 has been inserted. The registered value must prepare valuation report and maintain documentation in the format notified by the IBBI. तो इसके अंदर लिख दिया कि IBBI shall notify the format. This is a welcome step because it will standardize valuation report. Because practically what was happening was that till date everybody was giving his report as per every valuer was giving his report as per their wisdom. And but now this documentation, it's a procedural part. तो ये इसको हम इस तरह से करेंगे. Third is that Regulation 35 Sub-Regulation 3 has been inserted. It simply says कि पहले जो हमारे को valuation करनी थी, that was to be done under the company's registered values and valuation rules, so and so. No valuation as per standards notified by the RBBI. Again, this is a small shift there. Now there is a Regulation 35 के अंदर एक सब रेगुलेशन 8 नया ऐड करा गया है, which simply says that documents is to be maintained by the valuer as as notified by the IBBI. Although these amendments mainly pertain to valuers, but we as an insolvency professional are supervising their report, and hence we should need to understand this also. Another amendment is in the Regulation 31B in the case of voluntary liquidation. This is the same what we have discussed there. Ki valuation report as per format, documentation as per this thing like that there. These are the amendments. Anybody would like to add into it or would like to educate more on these amendments? Any of the expert or any of the
Yes, please feel free to say if you have any. निपुण जी आप कुछ बोल रहे थे?
हाँ जी प्लीज.
सर इसमें अमेंडमेंट में आई थिंक दे हैव अमेंडेड दिस बैंक्रप्सी प्रोसेस 1. सो इन व्हाट आई अंडरस्टैंड कि बैंक्रप्सी प्रोसेस में तो दे हैव पुट इन द वैल्यूएशन कॉन्सेप्ट, बट इंसॉल्वेंसी प्रोसेस ऑफ पीजी देयर इज नो वैल्यूएशन.
एग्री, यस, बिल्कुल.
सो दैट गैप इज स्टिल देयर. दैट इज वन. नंबर 2 सर, व्हेन आई वाज एनालाइजिंग.
निपुण जी इसमें मैं एक थोड़ा सा ऐड करना चाहूंगा. देखिए अल्टीमेटली जब हम एसेट सेल करते हैं वो बैंक्रप्सी प्रोसेस के अंदर आता ही है, और एज फार एज एक्सेप्टेंस ऑफ प्लान एंड देन प्रोसेस इट्स हार्डली आई थिंक 2 or 3%. दैट इज व्हाई IBBI might have thought that just for 2 or 3% let's not trouble to our.
पर सर अभी क्या हो रहा है, नाउ द हाईएस्ट लिटिगेशन इज कमिंग. पीजी इज ब्रिंगिंग अ रीपेमेंट प्लान. इफ यू आर रिजेक्टिंग, ही इज क्वेश्चनिंग. And I am myself handling 2-3 different high courts where they have got a stay. They are saying कि हमारी प्रॉपर्टी के ऊपर इतना वैल्यू है. I have been declared insolvent. मेरा वैल्यूएशन ये है. If bank is rejecting, let them say on what ground they are rejecting. The complete process is silent on valuation of the asset, and also it is silent on if you are rejecting a repayment plan. Like we have brought in कि COC को resolution plan के time क्या ध्यान रखना है, but there is no parameter if the COC in PG matter is rejecting, what are the reasons. That there is no concept of giving reasons.
सर इसमें मैं आपको एक छोटा सा आंसर देता हूँ. हेयर कट इसके अंदर 98, 99, 97 सिर्फ COC को वही समझ आता है, इसके अलावा और कुछ समझ नहीं आता. मेरे भी सब PG मैटर्स के अंदर यही हो रहा है. द मोमेंट दे सी 97, 98, 99% हेयर कट, दे से let bankruptcy be started against him without analyzing, without realizing what we had discussed earlier. What is the value of the backup securities or backup assets?
So I have also invited my very good friend, Mr. Parag Seth. He is a very renowned valuer and also advising on international valuation. So I have asked him to be here because he is an empaneled valuer also for Benami, for PMLA. So I just wanted him also to throw some light, because there is one new concept of coordinating valuer. Which is for the first time it has been brought in. So I was discussing with him कि coordinating valuer का काम होगा क्या, and how these 3 different classes will be coordinated.
सर वो आएगा CRP के अंदर. तो अभी मेरी कमिंग स्लाइड्स के अंदर आ रहा है.
तो
Parag ji, we welcome you. Parag ji, we welcome you. And we welcome you not only as Nipunji's guest but our IPA guest also. तो वी वेलकम यू. तो ये निपुण जी इसके अंदर 2 कंसेप्ट आ रहे हैं. एक आपने अभी बात करी, इसके साथ एक एंटरप्राइज वैल्यू का भी कंसेप्ट आ रहा है, वो भी हम लोगों को थोड़ा सा समझना है. और कोऑर्डिनेटेड वैल्यू एंटरप्राइज, दीज आर द न्यू कंसेप्ट्स. तो हम अपने इंसॉल्वेंसी प्रोफेशनल ब्रदर्स के साथ अपना जो नॉलेज है शेयर करेंगे. तो लेट्स मूव फॉरवर्ड.
और एक चीज मैं बस इस पे बोलना चाहूंगी कि जब भी आप पढ़ें तो फाइनली मतलब बहुत ध्यान देके पढ़िएगा, क्योंकि कोऑर्डिनेटिंग वैल्यूअर सिर्फ फेयर वैल्यूएशन के लिए लिखा हुआ है.
हाँ जी.
देयर फॉर लिक्विडेशन वैल्यू.
Let me go to the slides. Let me go to the slides.
Absolutely.
Let me go to the slides. Let me go to the slide. We shall, Mamta ji, look into it. Sorry, ये आपके friend इस बारे में कुछ कहना उन्होंने? And anything he would like to say that
No, I
ये
think we'll proceed. If at all there, I will definitely participate and give my
नहीं
views.
प्राग जी, अब इन्होंने देखिए, since निपुण जी has said that you are a renowned valuer, तो अब ये do you feel that IBBI be able to bring valuation standards which they are saying that notified by them, creation of valuation standard in itself is a curriculum task. Do
Correct.
IBB has expertise to define valuation standards, or or they will do simply do कि प्लांट एंड मशीनरी के लिए जो इंस्टीट्यूट ने ये जो वो जो इससे रिलेटेड इंस्टीट्यूट उसने जो कर रखा है, फाइनेंशियल के लिए जो इंस्टीट्यूट चार्टर अकाउंटेंट ने कर रखा है वो होंगे, और क्या नाम इसका, लैंड एंड बिल्डिंग के लिए जो आर्किटेक्ट की इंस्टीट्यूट होगी इन्होंने कर रखे हैं. डू यू फील दैट थिंग विल गो देयर इन, और सिंपली दे विल come out like our institute has come out with India's like data standards or like that? Do you feel that IBB have be able to do that? Praji, short comment
No,
on that.
sir, there is a gap in since more than 10 years, I would say, since inception of IBBI and IBC came. There is no such standard because valuation is always a gray area in particular. Because of, as all of us know, there has been a certain things are there in books, certain things are in plant and machinery. There is always a gray area. Today also there are less than 600 valuers for plant and machinery asset class. I am personally qualified for land and building. So we are having parallel economy is always a question, what has been funded at the time of funding and credit facility and what is there on the CIP date. So our institute as a IOV or any RVO who is dealing with the land and building valuations or plant and machinery, there is as such no activity going on to best of my understanding for making a draft. So normally whenever we have issued reports or people have seen, there may be IVC or IVSC has been taken. As such, ICSI and ICAI have a establish systems to come with the draft public comments and make those things happen in the SFA. But other two class or comprehensively, all three class together, or the enterprise value, what has been now just out of that new amendment, what we are looking, whether it is going to definitely, there is no, what I can say, a set procedure or a guideline or a rules anywhere which can define all these things, because it will definitely going to a challenging for anybody. And again at this, what I can say, sir, coordinating valuation, again that would be a how to interpret that is to be important.
चलिए सर, you just you just said what I said, that it will be a hurricane task for the there. Let's
True.
for IBBI to specify standards for valuation.
तो मनोज जी,
हाँ जी सर. Yes,
मनोज जी,
please.
अभी तक इवैल्यूएशन का कुछ पेपर तो उन्होंने सर्कुलेट नहीं किया. सर्कुलर वो लिखा है उसने.
नहीं, अभी कुछ नहीं करा, अभी नहीं करा. वो क्या स्टैंडर्ड्स हैं, क्या फॉर्मेट है रिपोर्ट का, पर उसमें मैं आपको एक आइडिया दे सकता हूँ. जो ये हमारी 14/11/25 और 19/11/25 को डिस्कशन पेपर था, उस पर इन्होंने एक ड्राफ्ट फॉर्मेट दिया हुआ था, तो आप उससे आप थोड़ा सा आइडिया ले सकते हैं कि आपको किस फॉर्मेट के अंदर रिपोर्ट देना है. ओके, चेंजेस इन नो लेट्स मूव टू द CRP amendment. We habitually we start calling it as a CRP amendment, although it is insolvency resolution process amendment. Change in CRP, what broadly it says, just a recapitulate and then we delve into each regulation. But changes in CRP framework, proposed amendments appear to be aligned with the discussion paper dated 17/11/2025. Changes in valuation framework, the proposed changes are consistent with the discussion paper so and so. CRP के बारे में 17/11 को आया था, और इसके बारे में वैल्यूएशन के बारे में 14/11/19/11 को आया था. No introduction of a new concept. That is that initially I stopped Anil ji also and Parag ji also. Now the question of enterprise value has also a new concept which we as an insolvency profession must understand. A concept of enterprise value as a more comprehensive indicator of corporate worth. Appointment of process coordinator, again we need to understand, to streamline the communication and procedural coordination. Standardization of valuation practices through uniform valuation standards and methodology. तो ये एक हमारा ब्रॉडर वे से ये इसके अंदर चेंज है. अब इसके अंदर ना आई वुड लाइक टू टेल यू व्हाट एंटरप्राइज वैल्यू इज. If my expert Mr. Parag will be understanding it, but as far as VIPs or who are either not CA, me is CA, but CA plus non-CA should understand what enterprise value is there. तो
Parag ji is also an IP, sir. I forgot to tell.
Oh, Parag ji, welcome. चलिए, तो तो इसमें मैं ये कह रहा हूँ कि व्हाट एंटरप्राइज वैल्यू इज एट प्रेजेंट व्हाट वी आर डूइंग, यू नो, whenever we are having a valuation report, we go for the three aspects: land and building, this plant and machinery, and security financial assets. इन तीनों की हम वैल्यू कर लेते हैं और इनका जो टोटल करके कर लेते हैं. बट मेनी अ टाइम्स इन द केस ऑफ a particular enterprise, this is not the actual value. I can give you an you know, I would like to make you to understand it with three examples जो मैंने मेहनत करके इंटरनेट से ढूंढे. You know, if we have gone with this concept, तो फिर ये जो मैं आपको तीन एग्जांपल दे रहा हूँ, तो इनकी एंटरप्राइज वैल्यू के बेस पे जो ये डील्स हुई मार्केट के अंदर, तो ये नहीं हो पाती. My first example is, you know, Google acquired YouTube on October 9, 2016 for 1.65 billion, meaning thereby that 7,500 crore rupees at that time, because at that time 45 was the price of the dollar, uh, which was founded hardly a year ago, the 2005 by Mr. Harley, Mr. Kareem and Mr. Chen. तो अगर हम अपनी ट्रेडिशनल वैल्यूएशन मेथड के हिसाब से करते तो इनकी वैल्यूएशन 7,500 करोड़ रुपए नहीं आती, हार्डली 30, 40, 50 करोड़ आती. बट दे वर हैविंग ए, यू नो, प्लेटफॉर्म ऑफ सो मेनी सब्सक्राइबर्स एंड सो मेनी दिस थिंग विच इज वाज एन हिडन एसेट. तो नाउ IBBI says that whenever you go for valuation, you should have the enterprise valuation of like that also. That was that international scene. Another scene I tell you in the case of Byju's also. You know, if you remember, Byju's also purchased Akash Educational Services in April 2021 for nearly 1 billion, again equivalent to 7,500 crore rupees, for which they paid 4,400 crore rupees in cash and 3,100 crore rupees in equity. That is the second aspect, that after buying such a hefty price, Byju went into insolvency. So that is, so you know, in that case also, since Akash, Mr. Chaudhary was the owner of this thing there, and they were, you know, from Delhi only and known to a little bit to us also. He was not having any assets of landed buildings, security financial assets, and this thing there. What he was having 250 centers all over India, and where they were, you know, having teachers based on salary or profit sharing basis, but there he was having student base against that thing there, and as a result of which he was able to value this thing there. No, the you know, that is there. Similarly, we you know, I have seen also practically when our companies in 2017-18 get converted from this gap to India's requires our accounting to, you know, our assets to be valued on market price basis. At that time, we also did you know, same thing we did for conversion. You know what happened, that in case of our distillery, we यही हमने तीन तरह की वैल्यूएशन करी इसके अंदर, एंड इट केम आउट टू बी 200 रुपीज. बट लाला जी कहते थे मेरी डिस्टिलरी तो 1,000 करोड़ रुपए की है, आप कैसे इसकी 200 करोड़ की वैल्यूएशन कर रहे हो. तो उसके अंदर हिडन ये था कि द काइंड ऑफ लाइसेंसेस व्हिच ही गॉट इन डिस्टिलरी, अर्लियर इट वाज बीइंग, you know, given at 1 crore rupees, later on because of so many distilleries in the state, and yeah, this wine being a state subject, government stopped giving licenses to distillery, and its prices was running into few hundred crores of rupees for existing distilleries. तो enterprise value जो है many a times is very important. Now we have to look into that, you know, whenever we are going to do this thing here, go for the valuation instead of three valuations only. No. Who will determine this enterprise value? It will be determined by the process coordinator. What process coordinator is the, who's process coordinator? It is duly defined in the regulation. Let me, you know, move forward with my this slide, and then I'll let you know with this thing what is there. Another important aspect there is in the case of CIP amendment is that it has granted a lot of relief to the home buyers. Special provisions has been inserted whereby lotteries, home buyers who fail to file their claim, even then SRA has to take care for those non-filed claims. You know, but at the same time, you know what pitfalls it has is that particularly challenge in implementation. Requirement to file an IO within 1 week, which we have already discussed in detail already. Preparation of CRP costs, we have already discussed. Increased compliance burden, which we have already discussed when we were discussing points therein. Same, you know, my sub point 2 is there. You know, getting reliable financial and operational information from cost for corporate debtor is hurricane's task, especially for small assignments. What bankers are, you know, looking for? bankers, they're putting a lot of responsibilities on the bankers, that at the time of approval of the plan, they will discuss this thing. But do you feel that practically bankers will ever indulge into it? I would like to have opinion of Mr. Shantanu and Mr. other senior IPs also, because what I found, I may be subjective in that way also. Their only objective is recovery and only recovery. Number one. Number two, voting time prescribed is minimum 48 hours and maximum 7 days. I have never seen, where public sector banks are enrolled. I might have done around 50 such cases. They have ever, where they did not ask for the extension. In all the voting, they ask for the extension, and many a time I'm running one process there, very, very small process there, and this process is being delayed only because of the delay in the voting by the State Bank of India. So,
You're true.
why I'm saying this thing is that whenever any amendment is coming out to be there, it should be seen what the ground reality is there. Another my IPA demand is that we should have relaxation for smaller assignments. We are prescribing procedure, even if Anil Ambani's company is going into going to the insolvency. We are prescribing the same procedure even if a company in the first COC meeting has decided to go for the liquidation. We should give some relaxation to those small companies. You must have read what I've written there. Smaller CRP cases may require regulatory relaxation or simplified compliance mechanism. This is quite prevalent. Quite prevalent if we look into our Companies Act, if we look into our MSME Act, a lot of relaxation is given there. Even in the banks also, whenever they go for the funding, MSMEs is given a lot of relaxation in the documentation also. तो ये एक हमारी तरफ से सीआरपी के अंदर था. अब इसके अंदर क्या क्या चेंजेस हैं, कैसे कैसे हैं, तो लेट मी come out with there. We have already understood 3 changes in the case of bankruptcy, in the case of voluntary liquidation, in the case of liquidation. I repeat again, Mr. Nikunj is saying that insolvency decision process for PG to CD section 94-95 application, there is no addition therein. And why there is no addition, Nipunji has given his expertise. But other than that particular chapter 3A, there are changes in valuation everywhere. CRP percent pre-package, both what those changes are there. Both amendments mainly focus on valuation methodology, disclosure requirements, and treatment of real estate allottees. Uniform valuation framework across IBC processes, introduction of valuer set. That concept, we need to understand what valuer set is there. Each set, one valuer per asset class, one coordinator valuer, standardization, valuation, computation, average of 2 closers estimates, third valuer allowed if 25 more than 25% difference is there. इसको मैं आपको इस तरह से समझाता हूँ कि हमारे एग्जिस्टिंग के अंदर क्या होता है. V.3 वैल्यूअर्स, एक लैंड एंड बिल्डिंग, एक फाइनेंशियल एसेट, एक प्लांट एंड मशीनरी. तो इसी तरह से हम 3 वैल्यूअर और करते हैं, बिकॉज वी आर रिक्वायर्ड टू अपॉइंट 2 valuers for each class.
Very
Now,
interestingly, yes, Manoj, please go ahead.
yes, Mamta ji, please.
So I was also wanting to say that very interestingly, they have also said that third valuer you can also appoint if the COC wishes to have a third valuer. And the reasons for having a third valuer has to be properly and diligently mentioned in the minutes as to why there was a requirement felt of a third valuer. तो थर्ड वैल्यूअर पे काफी अच्छा फोकस इन्होंने दिया है.
मैं बताता हूँ, अभी हम उसको ना जो रिलेवेंट रेगुलेशन है उस पर जब आएंगे तो मैं आपको बताऊंगा. उसके अंदर 2 ऑप्शन दी गई हैं कि सीओसी किन 25% से ऊपर का जब वैल्यूएशन होगा तब वो उसके अंदर करेंगे. नो, दिस अमेंडमेंट इज ब्रॉट देयर. तो अभी मैं जो है ना एक ब्रॉडर एस्पेक्ट से बता रहा हूँ कि ये जो हमारा जो कंसेप्ट है, जो हमारा ईच इंडिविजुअल वैल्यूअर थे, नाउ वी हैव टू पॉइंट सेट ऑफ वैल्यूअर. Set of values being, because now, as I told you earlier, because we need to determine the enterprise value now also. तो हमारे को सेट ऑफ वैल्यूज ये इस तरह से करने पड़ेंगे कि एक, जैसे लेट्स अंडरस्टैंड कि एक एंटिटी है, उसके पास तीनों टाइप के वैल्यूज हैं, तो उसको फिर हम वी नीड टू पॉइंट वन एंटिटी फॉर डूइंग ऑल दिस वैल्यूएशन, and we need to point another entity also who be having these three values there. Now, as far as appointment of each individual values is concerned, I don't know how practically that be possible. In my opinion, that situation will go off until unless we have a case where only out of three we have only one or two type of assets only which require valuation. In that case, we can go for we can go for the difference therein. Enhanced disclosure in another CRP process के अंदर amendment है. They are coming out with the enhanced disclosure in the information memorandum. What those new disclosure are? You need to mention receivables. Practically receivables मैंने तो जितने वैल्यूएशन करवाए हैं या तो 3 साल से ऊपर के होते हैं या उनकी वैल्यू जो भी वैल्यू हो रहा है एक बड़ी नेग्लिजिबल सी वैल्यू करता है. बट IBBI thought in their wisdom it should be mentioned separately, although their book value is definitely mentioned in IM. जॉइंट डेवलपमेंट एग्रीमेंट्स, अनिल जी ने इसके बारे में बताया. तो दी दैट इज वेलकम फ्रॉम अटैच्ड एसेट. Attached asset, we have seen lately that ED is attaching lot of assets. They say PMLA will prevail over IBC. अब PMLA versus IBC अगर इसको हमने समझने तो उसके लिए हमारे को एक अलग से वेबिनार करना पड़ेगा. But now they say in IM you should mention assets attached by the mainly by the PMLA, under PMLA by ED. रियल स्टेट लॉटिस अभी हमने डिस्कस करा कि रियल स्टेट लॉटिस के लिए कोर्ट हैज़ अ लॉट ऑफ सिंपैथी दैट बिकॉज ऑफ एनी रीज़न इफ़ दे डोंट फाइल क्लेम बट लेटर ऑन दे कम टू द कोर्ट एंड से कि मैंने पैसे उस डेट में दे दिए थे. मेरे से आज ही मैं केस देखा था, उसमें 2200 दिन का उसके पास डिले था. तो कोर्ट वॉज क्वाइट सिंपैथेटिक कि 2200 दिन का डिले का रीज़न हमारे को बताता हूँ, हम आपका डायरेक्शन दे देंगे RP को टू एक्सेप्ट योर क्लेम बिकॉज प्लान अभी हुआ नहीं था. तो प्रोटेक्शन फॉर रियल एस्टेट होम बायर्स. New regulation 38A ensures registration plan must address lotteries were not filed claim. Another no problem come out to be there that we have already discussed information not with RP. Improved documentation, this we have already discussed. So these are the essential feature of these CRP claims. Improved documentation will definitely is a welcome step. IBBI format will be there. IBBI valuation standards will be there. Working capital, what type of working capital will be there, that is prescribed. And definitely, valuer has to preserve those. It will reduce definitely litigation. And in case of any subjectivity, audited will be there. And professional accountability definitely will be, will be there, and it will be documented also. Reduce arbitrary net subjectivity. So, okay, now we come to the regulation wise, what changes are there. CRP regulation 2016 regulation 2 definition of fair value. Earlier fair value definition exists, but it was having a very narrow meaning. Now expanded definition includes total estimated realizable value of all assets including tangible, intangible and underlying synergies. तो अंडरलाइंग सिनर्जीज मैंने आपको जो बताया 3 एग्जांपल से बताया कि मेनी अ टाइम्स आपकी करंट एंड नॉन करंट एसेट्स की वैल्यूएशन टोटल मिला के नहीं इतनी आती जितनी एंटरप्राइज की बिकॉज ऑफ अंडरलाइंग सिनर्जीज करके वैल्यू ज़्यादा होती है. तो नो कोऑर्डिनेटेड वैल्यूअर हैज़ टू डिटरमाइन दैट वैल्यू ऑल्सो. So clarifies comprehensive valuation of corporate debtor underlying synergies means the additional value created when different assets of the corporate debtor are used together as a running business rather than valuing each asset separately. तो पराग जी एंड शांतनु जी एंड निपुण जी इसके बारे में कुछ एनलाइटन करना चाहें तो प्लीज कम फॉरवर्ड ऑन दिस अमेंडमेंट.
Sir, I will take it first. I would really appreciate EV enterprise value has been considered because I can quote couple of cases where I have done the valuations, or in one case I was IP. One case in distillery in Rajasthan wherein there is no, it's a dark zone, there is no permissions to be granted. Company was not going concern, but they were in the beer and manufacturing. So those companies would have a definite intrinsic value which cannot be valued by a land building or plant machinery or SFA valuations, because it has a licenses to operate. Anybody would take, and those things would be there. Somewhere else there was intangible value for the brand value. It was a listed entity wherein I was IP. That was also we have put before the COC in 2019-20. I am referring. COC has outrightly rejected. We do not want to spend money on this part. And ultimately, it has a carry forward losses, and those thing has been gone in a reasonable value. It was resolved, but there are chances there would be a better resolution. Price would have been, and creditors would fetch better money. So that enterprise value in a holistic approach, it's a good thing, specifically for a going concern. Yeah, anybody else? Santanu ji, please.
I think we can also add that coordinated valuer also. We can
Yeah,
discuss it
we
with
were
this.
coming with that slide. Coming with that slide.
Because, sir, that and this will have to be read together because enterprise value, I suppose, can only be done when there is a coordinating valuer for all the sets.
Yeah, we are coming with that regulation.
Sir, when you're talking about enterprise value, I understand ये जो आप the two instances that you gave, Parag sir,
Yes.
where brand was there and the brand could inherently be valued. Secondly, you gave this thing where the licenses were there. Licenses I can understand. Obviously, license if it is a valid license, काफी valuable हो सकती है. Now, अगर कोई company चल नहीं रही है, ओके फॉर क्वाइट सम टाइम, एक समय में उसकी कोई एक ट्रेडमार्क थी, अच्छी खासी ट्रेडमार्क थी, बट काफी टाइम से नहीं चल रही है, तो इस ट्रेडमार्क का वैल्यूएशन कैसे होगा इन दी ओवरऑल एंटरप्राइज वैल्यू? एंड अक्सर मैंने ये भी देखा है सर, एक दो केसेस जो मैंने हैंडल किए हैं, द ट्रेडमार्क इज टिपिकली ओन्ड बाय द अनदर एंटिटी एंड
Correct.
द कंपनी इज मेड टू पे रॉयल्टी. यूजुअली प्रोमोटर अपने किसी इसमें ये करके रखता है,
True.
यू नो. तो फिर इसमें फिर एंटरप्राइज वैल्यू कैसे निकालेंगे और किस बेसिस पे होगा? बिकॉज ये सब थियोरिटिकली तो बड़ा अच्छा लगता है, व्हाट एवर दे आर सेइंग, नो
It would
आर्ग्यूमेंट
be
विद
mainly
दैट,
for
बट
a going concern only, sir. So if it is not
हाँ
going
मतलब
concern for
गोइंग कंसर्न
trademark,
में
it
हो
is not
सकता
going
है.
to make any differentiate or substantial value for as an enterprise value. It will not be a
Because right
substantial
now,
component.
in my case, only right now I'm only having liquidations only,
Correct.
mainly Gitanjali James. गीतांजलि जेम्स के कुछ 22-23 ट्रेडमार्क्स हैं,
Correct.
ठीक है. अब उसकी वैल्यूएशन कैसे करें? 8 साल से तो कंपनी बंद है, और एक जमाने में उनके बुक में उन्होंने कुछ 400-500 करोड़ का कैपिटलाइजेशन दिखाया था कि मैंने ब्रांड पे इतने खर्च किए, पर 8 साल से बंद है, इसको क्या वैल्यू करें? पर
You can
ब्रांड तो
give the
है.
example of Kingfisher also.
हाँ,
Yes, same thing
किंगफिशर
as
ऑल्सो,
Kingfisher.
किंगफिशर में
They have
जैसे
taken
चार
something
हजार
on
करोड़ की
the brand
वैल्यूएशन
value
थी,
also.
40 करोड़ पे भी बिकी नहीं, अभी तक नहीं बिकी है. 4,000 करोड़ की वैल्यूएशन वाली चीज 40 करोड़ पे भी बिकी नहीं. और मैंने एक्चुअली ये सब के वैल्यूएशन कराए, मैंने ट्रेडमार्क को रिन्यू भी करवाया, जो जो रिन्यूएबल था,
True.
ठीक है. बट मुझे प्रॉब्लम ये आ रही है कि जो वैल्यूअर वैल्यू दे रहा है बहुत अच्छे से दे रहा है, बट आई एम नॉट कन्विंस कि उसमें बिकेगा. But he's given a formula-driven value. The rationale sounds correct on paper, but I don't know who will buy this at that kind of value that the valuer is actually giving.
सर
तो ये बहुत
शांतनु जी, आपका जो क्वेश्चन है ना, वैल्यूर से कम होना चाहिए. एक जो
हाँ
मार्केटिंग वाली एजेंसीज है ना, उनके पास होना चाहिए कि आप के वैल्यूएशन को कैसे रियलाइज करें. अब वैल्यूर तो एक जो अकाउंटिंग कंसेप्ट होगा, पराग जी थोड़ा सा एनलाइटन कर देंगे, उसका वैल्यूएशन करके दे देगा आपको. अब आप उसको कैसे मार्केट कर, मैं आपको सेम एग्जांपल बताता हूँ, मैं नेम भी ले लेता हूँ. जैसे आपने गीतांजलि
जी
का
जी.
नेम लिया, यू नो आई एम आरपी इन वन ऑफ दी पटेल वुड करके एक मेरे पास केस है, उसके अंदर हूँ. अब पटेल वुड का ना हमारी दिल्ली में बहुत नाम है. They were having a
अच्छा.
very big name as far as plywood and all this thing is concerned there, Patel wood and something like that. तो उस कंपनी के अंदर कुछ नहीं है, एवरीथिंग इज जीरो. 600 करोड़ के आसपास का टोटल डाटा है. मैं सिर्फ पटेल वुड के नाम से ही उस कंपनी को बेचने के लिए मैंने PRA SRA ले आया, बट अल्टीमेटली बिकॉज ऑफ दिस हैवी हेयर कट, IAB COC में तो मेंबर्स ने एक्सेप्ट कर लिया, बट व्हेन दे वेंट फॉर द अप्रूवल तो दे रिजेक्टेड इट. तो फॉर दैट यू नीड मार्केटिंग एजेंसीज की आपकी जो मन की वैल्यू है, जो जो वैल्यूर की वैल्यू है, उसको कैसे रियलाइज करो.
हाँ, बट वही चीज है कि थोड़ी डिफिकल्टी इसमें यही आ रही है कि पूरी जैसे इंडिविजुअल ब्रांड की वैल्यू हो नहीं सकती. इंडिविजुअल 8 साल से इंडिविजुअल ब्रांड वाइज कितनी सेल हुई कुछ पता नहीं, यू नो, हुई नहीं ना ऑब्वियसली.
There is
और
no
अब
data
जब
available.
देयर इज नो डेटा अवेलेबल, तो कैसे करें? और टोटल 12 ब्रांड का वैल्यू एक पर्टिकुलर आ रहा है, डू आई सेल द होल बास्केट? You know, these things, and frankly speaking, even the COC people are not in a position to give anything. So ultimately, they told me, तुझे जो करना है कर ले भाई,
सर
हमें
हर
भी
जगह
समझ
ये
में
ऐसे
नहीं आ
होता
रहा.
है. ये
हाँ?
शांतनु जी, ये हर जगह ही ऐसे होता है। सीओसी कुछ नहीं करती। जितने अमेंडमेंट्स आ रहे हैं ना, मैं आपको अभी एक और प्रैक्टिकल बात बता रहा हूँ। ये सीओसी की रिकॉर्डिंग के लिए जो उन्होंने कहा कि आप ये कंपेयर करोगे वो कंपेयर करोगे, अल्टीमेटली
नहीं हो पाएगा, मैं तो ढाला ही था कंपेयर।
हैमर इज गोइंग टू फॉल ऑन वी आरपीज, कि उन्होंने हमारे को ही कहना भैया इन चीज़ों को कंप्लाई करते हुए हमारी रिकॉर्डिंग कर देना आप। हमारे को पहले बता देना मीटिंग से पहले कि इन चीज़ों को हमने कंसिडर करना है, और हम इसको जो आप हमारे को बताओगे उसका असर पढ़ के इसको कर देंगे। दिस इज माई
एक्चुअली ऐसे किए सर,
एक्सपीरियंस।
अभी
दिस इज माई
लाइवली लाइव
एक्सपीरियंस।
एक केस किए हैं। ममता मैडम और मैं एक केस में काम कर रहे हैं। ममता मैम मेरे को रिप्रेजेंट कर रही है। तो एक्चुअली हमने सीओसी को लिटरली ऐसे बोलना पड़ा हमें कि बॉस आप ये बता दीजिएगा, बिकॉज बैंक्स आर ओनली लुकिंग एट रिकवरी।
सर मैंने पहले ही वो एक कहा कि बैंक रिकवरी एंड ओनली रिकवरी।
और तो
तो
कुछ उनको लेना देना नहीं है।
कुछ नहीं
बैंक हैज
लेना
नो
देना।
स्किन इन द गेम
सर
लेटर
कुछ
ऑन,
नहीं
नो।
है, उनको उनको कोई मतलब नहीं है कि कंपनी को, जो हमारा आईबीसी का ऑब्जेक्टिव है रेजोल्यूशन, उनको रेजोल्यूशन से कोई मतलब नहीं है, रिकवरी है। बट आई थिंक आर रेगुलेटर शुड रियलाइज दैट थिंग आल्सो, एंड एट द सेम टाइम दे शुड लिसन टू वी इंसॉल्वेंसी प्रोफेशनल्स आल्सो what practically we are facing the difficulties, and some sort of relief or some sort of amendment do also come out after listening to us also. But in any case,
आई नो दैट्स नॉट हैपनिंग, बिकॉज अभी अभी ये जो इन्होंने इतना सारा काम बढ़ा दिया है वो 30 डेज वाला, तो सर क्या करेंगे? तो ये जो फीजिबिलिटी वायबिलिटी ये सब जो निकालना है, कैश फ्लो वगैरह वगैरह, आप सीए भी हो, इवन इफ यू आर ए वेरी सीजन्ड सीए, आप क्लेम देखेंगे कि आप पहले क्लेम करेंगे कि पहले क्या करेंगे आप?
सर
थर्टी
मैं
डेज में
वही
इतना
कह रहा
सारा
हूँ कि
काम
मैंने
क्या?
जैसे पहले कहा, जब भी कोई नई असाइनमेंट आती है, चाहे वो छोटी है या बड़ी है, क्लेम वेरिफिकेशन, आप आईआरपी से आरपी बनोगे या नहीं बनोगे, सीओसी का क्या
उसकी कोई
कॉन्स्टिट्यूशन,
गारंटी नहीं है।
सीओसी का क्या कॉन्स्टिट्यूशन होगा, और उसके बाद आपके जो खर्चे होने होंगे उनको कैसे मीट आउट करोगे। यानी कि जो एक मैंडेटरी एक्सपेंसेस होते ही हैं, चाहे एडवोकेट हो, जब पेपर में एडवर्टाइजमेंट देना है, या क्लेम वेरिफिकेशन के लिए किसी को, जो वट एवर इज देयर, तो सर उसमें ही इतनी एनर्जी लग जाती है कि पूरी की पूरे रिसोर्सेज आपके आपके ऑफिस के जो भी दो चार पाँच छः बंदे काम करते हैं, सारे सारे उसमें लग जाते हैं। उसके साथ ये करना, एस्टिमेट बनाना, फिर उसको प्रूव करवाना, फिर वेरिएशंस को एक्सप्लेन करना, इट्स हैरिकल। चलिए सर कोई बात नहीं, लेट्स मूव
बेस्ट
फॉरवर्ड, लेट्स
बेस्ट
मूव
पॉइंट
फॉरवर्ड।
इज सीओसी में तो ऐसा कोई ऐसे होगा नहीं जो ये चीजों को समझता हो।
सर वो
यू नो,
टेम्परेरी जॉब होती है ना। अब बैंकर्स सीएफसी के अंदर जितने भी आते हैं, दे आर ओनली फॉर 1 or 2 years, दे डोंट हैव एनी एक्सपीरियंस ऑफ आईबीसी इन द पास्ट। दे लिसन फ्रॉम यू, हेयर फ्रॉम यू, एंड दे स्टार्ट टेलिंग ऑल दिस थिंग देयर। चलिए सर कोई बात नहीं, दैट इज व्हाई वी आर ट्रीटेड एज अ पिलर ऑफ द आईबीसी इकोसिस्टम, बिकॉज वी कैन हैंडल
और
ऑल
पिलर पे
दीज
इतनी वो
प्रेशर्स।
बोझ ढाले जा रहे हैं,
सर
पिलर
उठाए
कोलैप्स कर
सर।
जाएगा।
सर नहीं होगा सर। सर आप हो हमारे साथ, निपुण जी है हमारे साथ, ममता जी है हमारे साथ, और अनिल जी है हमारे साथ। दे विल कम आउट फॉर आवर रेस्क्यू। चलिए सर, इनफैक्ट नॉट ओनली फॉर माई रेस्क्यू, फॉर द रेस्क्यू ऑफ ऑल द आईपा मेंबर्स। चलिए नाउ लेट्स मूव टू द देयर इज अनदर अमेंडमेंट, रेगुलेशन 27(1), whereby RP has to point two values. No, RP has to point two sets of registered values within 7 days, but not later than 47 days. तो अब पहले हमारे को 6 वैल्यूज अपॉइंट करने होते थे, अब हमारे को रिमेंबर 2 सेट्स ऑफ वैल्यूज अपॉइंट करने हैं। रेगुलेशन 35(1), इसके अंदर अमेंडमेंट क्या है कि अब डिटेल्ड मल्टी वैल्यूड स्ट्रक्चर इन्होंने कर दिया है, फॉर्मलाइजेस वैल्यूएशन मेथोडोलॉजी, व्हाट वी हैव डिस्कस ऑलरेडी, कि इन्होंने ये करा है कि जो हमारी जो हम वैल्यूएशन करेंगे उसकी रिपोर्ट क्या फॉर्मेट होगा, कैसे होगा, लाइक डेट करके। और रेगुलेशन 35 के अंदर जो नया कंसेप्ट आया है उसके अंदर यह आया है कि coordinator value designated each set of compute corporate data as fair value। अब कोऑर्डिनेटर वैल्यू यहाँ पे 35 के अंदर उन्होंने इसको कराया। अब हु व्हाट इज द रोल ऑफ कोऑर्डिनेटर वैल्यू? तो लेट्स इट इज क्वाइट सिग्निफिकेंट। तो आप प्लीज, एनीबडी कैन कम फॉरवर्ड टू एक्सप्लेन द रोल ऑफ द कोऑर्डिनेटर वैल्यू, अदरवाइज आई शैल एक्सप्लेन। एनीबडी कैन कम फॉरवर्ड प्लीज।
Oh, so coordinating valuer is a concept. I'll just give you the overview of the concept. The concept is only, firstly, it is only applicable for fair value.
फेयर
Let's
वैल्यू।
be very clear about that. This concept does not extend to liquidation value. That's number one. Number two, they say that whosoever is like out, there are two sets, as has been put forward by Manoj. In the two sets, each set will have to have a coordinating valuer.
May I stop you? No, out of two sets, one will be the coordinated value.
No. I think it is in the both the sets you have to have a coordinating value.
No. What, because enterprise value तो एक ही बंदा determine करेगा ना, based on.
Okay, एक बार आप check कर लीजिए वापस.
अरे check कर लेंगे,
Anyway,
check कर
that we
लेंगे.
can
Maybe I be wrong.
just
हो सकता है.
deliberate.
Yeah, we can.
So
Sir, this is good, sir. If you can just put the text on the screen.
Yes, absolutely.
Because
So
this is something which we also deliberated, Parag bhai and me, on the same issue.
Do you want me to put the relevant regulation there?
Yes, sir.
Okay,
So let's
just hold
understand
on.
the concept. By the time that comes up,
Give me a moment. You go on discussing, please.
By the time that comes up, we will just discuss this. So there will be a coordinating valuer from each set which I recollect, subject to correction. Let's
Yeah,
understand
that's
the
correct.
concept. Yeah.
My reading is also that one coordinating valuer from each set. So,
Yes.
matlab, sir, if you are a SFA valuer or something, you can take a lead, tie up with a land and building and plant and machinery valuer, and as a तीन जन मिलके आप लोग को हम अपॉइंट कर सकते हैं
So
as a
like
RP.
so whosoever becomes a
Set.
so whosoever is selected amongst the three as coordinating valuer will also have to be given the stamp of selection by the COC. So COC should also agree that this person is a coordinating valuer. Okay. Now the coordinating valuer, of course, so there are two other things which we need to discuss while we do the coordinating valuer. That is that in the COC, one also has to discuss that what has been the process adopted to do the valuation, etc. That I'm sure you have understood the concept that everything will have to be put forward before the COC, before the valuation report is given in the COC. Okay, कि आपने क्या मापदंड use किया है, what are the barometers used, what are the standards used, etc. And as you have also noticed, that IBBI will soon come out with its own notification where they will say that what should be the format, I mean the structure of the valuation report. Not only the structure, they will also guide the valuation standards, if we may just use that word, which will now no more be guided by the valuation rules. They will have, IBBI will have its own set of rules, own set of format. Now this coordinating valuer, both the coordinating valuers will talk to each other and then come up with the fair value, the final fair value figure. So the role of the coordinating valuer actually takes a center stage. Now, when I was reading this, I actually was trying to understand that whether liquidation value has been given a miss or it is a deliberate attempt by the lawmakers. So then when you read it by fine print, you understand that it is only a deliberate attempt made where they're only covering fair value of enterprise value bhi bol dijiye, fair value is what has been given equivalent to enterprise value. Now, beautifully, as I was mentioning, that if you have a third, say for example, if you have a third set of valuers, then what will happen to the coordinating valuer? That is a question that comes to our mind, which I think we should address while we give our inputs to IBBI. Because अगर आप third set पूरा appoint कर रहे हैं, because of the difference in valuation of more than 25%, or if the COC decides, and that difference could be in the fair value or it could be in the liquidation value. Now, suppose fair value में difference है, so is there any concept of appointing another coordinator or coordinating valuer? So this is the overall thing that I wanted to mention. Manoj may now take this forward.
Okay. If we read what you are saying, which I've underlined, shall comprise of one registered value of each asset class for the corporate debtor, which within each set, one registered value shall be designated as the coordinated value. Okay, you're right. Thanks for improving me. Lawyers are always able to read very properly between the lines, and we, as an insolvency professional, always in a hurry to, put that thing, how practically we be able to implement that thing there. My understanding was that.
Thank you.
The thanks for, no, I'm thankful to you. You've been my teacher all the time. Okay. In case of no ambiguity comes in my mind is that yeah, if when we have for each set one coordinator value, and how enterprise value will be determined? Now we shall have three coordinator value. Am I right? If I'm not right, please correct me. When we have three coordinator value, earlier I thought ki, for each set we shall have for both the sets I shall have one coordinator value. No, no. How when we have three coordinator value, Mr. Parag just enlighten me, my IP brothers also. How then he will determine who among that three will determine the enterprise value, or any one of them, or something? What will be there?
सर
Yes,
सर
Nipun ji,
इसके
please, please,
सर
please.
इसके पहले जस्ट स्क्रीन पे इफ यू कैन जस्ट फ्लैश रेगुलेशन 27(1). जो कंफ्यूजन है इट इज कमिंग फ्रॉम दैट 27(1) एंड दिस इसके जस्ट ऊपर सर. यस सर, दिस वन, सीरियल नंबर 3. The RP shall within 7 days of his appointment but not later than 47 days from insolvency commencement date appoint 2 sets of registered valuer. सर यहां उन्होंने लिखा है 2 sets of registered valuer. यहां वर्ड 2 sets यूज किया है. And now if we read 41A, they say the set of registered valuer appointed under 27 shall comprise of one registered valuer from each asset class of the CD, and within each set one registered valuer. So they are trying to say कि set asset class wise है, या they are trying to say कि set is by default appointment of only 2 sets. So that is a confusion. Even Parag bhai and me were discussing. अगर हम 27(1) को देखेंगे, ममता जी, if you can see 27(1), वहां वर्ड यूज है appointment of 2 sets of registered valuers. 2 sets. So only 2 sets. That means
Each class.
Each class.
Hey.
One set is a 3 valuer. Each
Absolutely.
class. My understanding is one set is 3 registered valuers.
Correct, you're right.
3 asset.
एकदम करेक्ट पराग.
यही मैंने कहा था, बट नीचे आओगे तो फिर अब बात चेंज हो जाती है.
करेक्ट मनोज जी, एब्सोल्युटली राइट. दोनों जगह बात अलग अलग हो रही है.
तो इसका मतलब ये है कि मी आल्सो करेक्ट, ममता इज आल्सो करेक्ट, बट हु विल एडजुडिकेट हु इज करेक्ट?
करेक्ट. सो दैट विल बी
somebody
प्रोबेबली
has to adjudicate ना who is correct.
So
निपुण
हम भी
जी,
कंफ्यूज हो गए थे.
शांतनु जी, आप नहीं सर, अब मेजोरिटी वोट से चलेगा ना काम. या तो आप मेरे को वोट करो या ममता जी को वोट करो. आप 3 बंदे हो तो लेट्स.
So पराग भाई ने मेरे को बोला, फर्स्ट flash of these regulation was, Parag bhai said, Nipun, now I will also have to make a company like IPE, क्योंकि मुझे तीनों asset class का एक valuer appointment चाहिए. But when we read further, it creates something else.
Supposing you appoint RVE only, which is what I tend to do after this thing came in. So RVE तो तीनों क्लास का दे सकता है और enterprise value भी दे सकता है.
Correct.
So that saves me from the trouble of having to coordinate and appoint three
yes
individuals.
Yes.
Sir, अभी एक और interesting चीज है sir. I will ask everybody to look at sub clause B. उसमें interestingly word use है including coordinating valuers.
Correct.
So the word says coordinating valuers. So it has to be 2 valuers who are going to coordinate.
Right. I
Correct.
have to get this to cement my point. Absolutely.
I
So
think what
I
I
think
feel is
sets
that
पे clarity चाहिए from
नहीं फिर
IBBI.
देखिए इसका solution ये है कि IBBI should come out with a press release, clarifying कि what their intention is of coming with this amendment.
See, I can only say you that the rules of interpretation says, the principles of interpretation, that if the letter is clear, you need to go with the letter. So when the letter is clear that it says singular, plural, wherever plural and set and all that has been used, I don't think IBBI will ever need to clarify this. It is amply clear in the letter of law, proposed law rather.
नहीं, this is already notified, ma'am. This is notified now.
This is notified. I'm sorry. 25
No,
tools has been listed.
you do one thing, they have come out with some press release also on valuation.
और देखो क्या है,
That I have
With
checked, sir. That I
Yes.
have checked, sir.
हाँ,
But
वो
it
हमने
doesn't
भी
say
देखी।
anything, sir.
this doesn't say anything.
ये
It
बहुत
doesn't.
चलिए सर, कभी कभार कंफ्यूजन क्रिएट, कुछ चीजें ऐसी रह भी जानी चाहिए जिसके लिए हम दोबारा वेबिनार कर सकें।
सर
तो
सर इसी के बाद दे से कि वैल्यूएशन स्टैंडर्ड्स, वैल्यूएशन रिपोर्ट एंड डॉक्यूमेंटेशन, दीज थ्री थिंग्स आर न्यू. बट इफ यू रीड द बैंक्रप्सी अमेंडमेंट, द बैंक्रप्सी प्रोसेस अमेंडमेंट, there they have not removed that international valuation standards. They have not amended there. So that is again, I think, a miss from IBBI side.
ओके 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 ओके।
मैंने सारा देखा है, मुझे कहीं वो दिखा नहीं जो आप बोले निपुण जी, फिर भी I'll see it again.
Ma'am, if you see the bankruptcy amendment only,
हाँ,
it
I have,
is only amending that you are going to issue valuation and
right, I
report
have seen
and
that.
maintain documentation as notice.
Right, right.
Yes,
Oh,
but only for documentation. For valuation standard, the other sub-regulation in bankruptcy process is still continuing. They are not deleting that.
companies registered valuers and valuation rules will continue there.
Correct,
And
correct.
right, I
So,
have
so,
noted that.
so again, that is going to be an issue. And one more suggestion which I have given, that in PG's insolvency process, there is no concept of valuation. They have completely lost that side, because that is the only issue. In fact, I am facing 2 stays from High Court only with regard to valuation in PGK, saying the law is silent.
Actually, PG के लिए तो सीधा bankruptcy में valuation का concept लेकर आए, and the PG they haven't. I agree, they haven't.
No, but this is a
खुद
very
अपना
good point
पकड़ा।
pointed out by Nipunji. Nipunji, you are really, whole community is really thankful to you, pointing out, such a valuable input that, it's a learning for we insolvency professionals, that in case COC, MOC, there we have an MOC here.
Yes.
If MOC rejects your repayment plan, which is more than 99%, and in that case, you can get a stay from the High Court saying that our underlying assets, I'm giving more than what my underlying assets are there. And in that case, valuation concept, IBBI should have brought there ki, for underlying assets, you should adopt international, their proposed to be specified valuation standards. Because if you, as an accountant, if we see that if we go for the valuation under GAAP, if we go for the valuation under India's, there is a hell of a difference. GAAP says you have to go with a book valuation. India says you have to go with a market valuation.
And it's always said that, sir, fair value is never fair. Also, real estate may, I've seen cases, normally fair value is more than liquidation value. But in real estate cases, sometimes the liquidation value is more than the fair value. Because
God.
you are
Okay.
not going to honor the contracts if you go into liquidation. So all those home buyers who are unpaid home buyers, or I would say they have not been able to get the sale deeds done in their favor, those contracts go away into monetary claim. So in that case, the liquidation value exceeds the fair value.
Agree. Because
That point is gone in this regulation amendment. If we see, they are only focusing on fair value, not the liquidation value. So in my view, again, this does not solve the issue of real estate.
But that's a very, that's even I'm facing in one of the matters where I'm a lawyer. That all those comes back to the inventory. So therefore,
yes.
Liquidation value goes up.
चलिए, इसके साथ मेरे को भी एक पॉइंट पे बताना है कि फर्स्ट ऑफ ऑल लेट मी फिनिश दिस थिंग देयर, देन इन द डिस्कशन वी विल टेक इनटू दिस आई शैल आल्सो ऐड 2 or 3 points what Nipun ji has said. Okay, now regulation 35E we have already discussed. Third valuer appointment was absolutely the discussion of the COC. Now they have said that if the set of values, if there is a difference of more than 25%, then you can go for the third valuer. Here again, the ambiguity will remain whether this 25% difference will be seen among the class or set. पराग जी क्या कहते हो? 25% का डिफरेंस क्लास में देखना पड़ेगा या सेट में देखना पड़ेगा? निपुण जी, you also. Mamta ji, you also.
It should be in set only.
It is set. Okay.
Sir, my understanding is class.
You cannot. आप क्लास नहीं
पर
बेच
सर
रहे हो
एक
ना,
बात,
यू आर नॉट रिजॉल्विंग क्लास, यू आर रिजॉल्विंग सीडी।
पर समझ लीजिए अगर कोई लैंड एंड बिल्डिंग का किसी ने एक्स वैल्यू दिया, दूसरा वैल्यू सेट ऑफ वैल्यूअर ने उससे 25% के नीचे दिया, और फिर और कोई एसेट में किसी ने एक दिया, वो सब्जेक्टिव नहीं हो जाता? तो मेरे हिसाब से तो सर यही होना चाहिए कि अ, अगर दोनों क्लास में कोई फर्क आवे, ईच क्लास
25।
वाइज चलना चाहिए।
So then third
सर
valuer should
सर
be
सर
applicable
सर
for
सर
class
सर लेट
only
मी,
or a set.
वी वर ऑलरेडी एक्सीडेड 20 मिनट्स। तो कुछ चीज़ें ऐसी होती है, उसको कंट्रोवर्सी ही रहने दीजिए। जब तक 27(1) और 35 क्लियर नहीं होगा, ये कंट्रोवर्सी रहेगी। एंड वी लेट्स कंटिन्यू दैट कंट्रोवर्सी। एंड शांतनु जी, आप अपने केसेस में वैसे करना। पराग जी, आप अपने केसेस में वैसे करना। और
सर
अब
सर
मेरे
मजे
तो
की
पास
वैसे
बात
ही
है
हो रहा है सर।
और मेरे
सर।
पास जब कोई केस आएगा, तो मैं आप दोनों को कंसल्ट कर लूंगा, और जिससे मेरे को मेरी सीएससी को बेनिफिट लगेगा, मैं वो केस कर लूंगा।
सर इसमें कोई कंट्रोवर्सी की जरूरत नहीं है अभी, क्योंकि ये दो इट हैज बिकम द लॉ, इट कैन नॉट बी इम्प्लीमेंटेड क्योंकि वैल्यूएशन स्टैंडर्ड है ही नहीं एज पर दिस
सर
अमेंडमेंट।
सर
इट इज
ये
नॉट देयर।
मैं वही बता रहा हूँ। वैल्यूएशन स्टैंडर्ड्स वर्किंग पेपर हो सकता है हमारे नेक्स्ट वेबिनार करने से पहले आ जाए, तो वो तो कभी भी आ सकते हैं ना,
सर आई एम अवेयर, वो है ड्राफ्ट में ऑलरेडी,
हाँ
एंड
जी, हाँ जी,
इट इज ऑलरेडी अंडर, आई हैव गिवन सम इनपुट्स, सो आई एम अवेयर। सो इट हैज ऑलरेडी बीन प्रिपेयर्ड, पर इतनी जल्दी नोटिफाई होना इज नॉट पॉसिबल।
इट्स अ वेरी बिग टास्क, वेरी ब्यूरोक्रेटिक टास्क। चलिए, दिस 35FG average valuation used but not clarified now closes estimate standardized computation. We have already discussed all this. 35(1)(e) new inserted different value must prepare valuation report and maintain document. We have already discussed. CRP regulation 36(2) IM. The IM is something new coming out of the box from valuation. Additional disclosure requires limited disclosure, strengthens information available to the RP. Regulation 36(2) details of receivables, including trade, intercorporate, contractual receivables. What is the objective behind of such a detail in the IM of related to receivable, when we practically are seeing that every valuer is giving it a very not value for all this as a market value. Most of the cases what I have done, my friends can also share with them. अगर debtors या इसको we call them as a current asset. Let's exclude inventory out of current asset. अगर करंट एसेट्स के अंदर वैल्यूएशन अगर 100 करोड़ रुपए भी है, 50 करोड़ रुपए भी है, 10 करोड़ रुपए भी है, या 10,000 रुपये भी है, तो वो वैल्यूअर उसको जीरो या बड़ी एक नेग्लिजिबल सी वैल्यू करके देता है उसको, विच इज़ हार्डली 0.1% और समथिंग लाइक दैट। तो उसको स्पेशल इतनी ज़्यादा वो यहाँ पे एक वो देना, एक इम्पोर्टेंस देना, व्हाट इज द रीजन बिहाइंड दैट? एनीबडी कैन, इफ ही नोज ही कैन एनलाइटन अस।
Sir, I can tell you that there are around three cases which I am fighting before NCLAT, where what has happened is NCLT, even there was a resolution plan, it was rejected, saying that the value of the debtors is much more. So let me give you an example. The resolution plan was, let's say, 50 lakhs, and the debtors, according to the IM, it was more than, let's say, 50, 60 crores. But according to the valuer, since they were old debtors and some foreign debtors, it was not recoverable. That was the view. And therefore, they approved a plan. And interestingly, sir, that plan was also of an IP only. So the RA was also an IP. So that particular plan got rejected from the court, saying that, sorry, it is not for revival. Probably you will do litigation and get that money from the debtors. So it is a receivable. So therefore, we are rejecting. Now it is pending before NCLAT. Let us see what NCLAT says. But this is a trend which is now coming up, that if the court are seeing that there is a huge amount of receivables, they are not allowing the plans to go with, because the value is much more.
Especially if you have some GST input credit, if you have income tax refund which get tied up because of demand from the other years. So that I'm adding to you, that trend is developing in the IBC also. चलिए, details of joint development agreement, the collaboration agreement. This is a it's a disclosure, in my opinion, was required because it was materially affecting especially home buyers cases. Regulation 36(2) AC amendment. There was no provision. There is details of assets attached that force agencies we have already discussed. Details of real estate allottees, the JA, we have already discussed. 38A, registration plan must specify treatment of allottees, we have already discussed. This is a welcome step, because अगर कोई होम बायर्स किसी कारण से क्लेम नहीं फाइल कर सकता, तो उसकी डिटेल तो एटलीस्ट आरए को पता होनी चाहिए ना, so that SRA can make provision in their plan कि if ultimately court allow them to as a financial creditor, then I must have a provision for that.
Rashid,
Yes,
yes,
please carry on.
Manoj.
Carry on.
Manoj, just to add on this, sir, actually this has occurred and this proposal for both these two regulations, I must tell you, IBBI held the IP guilty, saying that if there were some allottees which were known to you because of customer data, so there was a customer relationship data which was there, but it was not matching with the claims which have been received. So some of them were not featuring in the CD's assets because they were not, CD's books because they were not shown there. But in the customer data, we could find that these people have paid. Now, in that resolution plan, the plan was approved. There was a specific mention that there are so many allottees, but since their claim have not come, so we are treating them as zero. We are not paying them. Plan got approved. It got approved from NCLT, from NCLT, और सर आपके NCR का ही मैटर है, but the IP was fined for suspension by IBBI, saying that when there were some customers, because then they approached directly Supreme Court now, home buyers, saying that we were not aware, our claim is not taken, and we are given our hard-earned money for those flats. Now, in that case, obviously, this matter is now before High Court. We have got a stay on the suspension of the IP. We have argued that there is a statement already in the plan. If there is a claim before the IP only, then we are required to consider. If not, then we will only make a statement in the resolution plan. So I think probably because of that, this amendment has come, wherein now they are saying if the data is available as per RERA or as per any other document, you will have to mention it that these are so many customers still.
Okay, what Mr. Nipun is saying, that as an IP, when we are running a process, we not only have to look into the books of the accounts, we not only have to look into the customer's account, we have to look into the RERA accounts also and make the reconciliation of all these three aspects in the case of home buyer's case, and do mention that reconciliation in the IM also. Or try to approach to the home buyers who has not filed their claim, but for whom we are able to get data either from the RERA or from the customer, or any similar that situation is there when we are doing home buyers case. Yes, somebody was coming out to be there. Please come forward.
I was wanting to ask, supposing, like in this case, you are saying there was a customer record, right? But it was not there in the books of account. So whether these home buyers have actually paid some money to the corporate debtor for booking their home, or they were only on the customer record, matlab they had done an inquiry. Like when you do an inquiry with a customer team of that builder, your name, number, whatever may be in the district, in their record.
पैसा दिया था सर उन्होंने पैसा दिया था,
जिन्होंने पैसा दिया वही आएंगे, जिनका पैसा नहीं है वो तो आ ही नहीं सकते, उनका तो क्लेम कहां से लाइव होगा?
वो डेटा हमने बाद में वेरीफाई कैसे किया, CRM डेटा, कस्टमर रिलेशनशिप मैनेजमेंट डेटा से हमने उसको क्रॉस चेक किया, उससे क्लियर हो गया कि पेमेंट हुआ था, बट द प्रॉब्लम वाज कि प्रमोटर्स वर इनसाइड कस्टडी, सो दे वर नॉट देयर कोऑपरेटिंग. प्लान आया, प्लान गया, प्लान अप्रूव हुआ, देन दीज इश्यूज केम, क्योंकि कुछ जो अलॉटीज थे दे हैड गॉन टू NCLT, उन्होंने कॉन्डोनेशन अलाउ करके उनको अलाउ भी कर दिया, बट एक बंच ऐसा था who did not approach NCLT, plan got approved. Plan में mention भी किया है कि there are some customer relationship data allottees which have not filed their claim, and we are giving them zero. The plan also says we are giving them zero. But now that question is whether you can allot zero or not. That is now gone to Supreme Court. But we have got the stay on the suspension of the IP.
But yeah, that's good. That is a
Okay,
good remark
उसकी
in
yes.
IP is webinar where IPs are dominating. तो IPs अगर आपके पास कोई भी ऐसी परेशानी है जिसमें आपको लगे DC को ने शो का इशू कर दिया तो
निपुण सर
get in touch with Mr. Nipun and he will help you in questioning that particular show cause. चलिए सर ओके तो अब बट as far as my understanding of law is concerned, Supreme Court is very sympathetic until unless he finds that the investor is a speculative. They always allow their claim in under IBC. This is my understanding of home buyers case as far as Supreme Court's interpretation is concerned for their claim. प्री पैकेज ये सेम ही है जी इसके अंदर फेयर वैल्यू की डेफिनेशन वैल्यूज वैल्यूएशन मेथोडोलॉजी इट्स द सेम व्हाट वी हैव लर्नड इन द CRP and only thing is कि just for the sake of updating I mentioned the relevant regulation and all this thing there. आधा घंटा ऑलरेडी ऊपर हो चुके हैं तो आई एम लिटिल बिट रशिंग अप या दिस इज ऑल Regulation 39A, documentation, registered valuer must maintain valuation report. Now, this is all from our side, all from IPA side today. And with closing remarks by all our experts, maybe Mr. Parag, Mr. Shantanu, Mr. Nipunji, Mamtaji, and or anyone else also, please come forward. And with this, then we, close on the meeting. We already exceeded our half an hour.
No, sir, thank
Very
you.
enlightening
Thank you for conducting
session.
such webinars.
very enlightening session sir.
सर देखिए मैंने एक बात पढ़ी थी अगर आपने किसी किताब को इंटरेस्टिंगली पढ़ना होता है ना तो आप उसको शुरू से मत पढ़ो 20 से पढ़ना शुरू करो तभी आपको एक्साइटमेंट रहेगी सिमिलरली इन आवर वेबिनार इट हैपेंस हम लोग कुछ इश्यूज को रिजॉल्व कर लेते हैं और कुछ इश्यूज अनरिजॉल्व भी छोड़ देते हैं तो जो अनरिजॉल्व इश्यूज होते हैं वो एक डिस्कशन से ही इमर्ज होते हैं नीदर मी नॉर ममता जी और नॉर निपुण जी और शांतनु जी और as an individual is expert in interpreting law
Absolutely.
as per their point but when 5 people interpret law in their own room and then they come out with this thing कि जैसे मेरा ममता जी के साथ एक ओपिनियन हो गया सेट ऑफ वैल्यू और क्लास ऑफ वैल्यूज देन एंटरप्राइज वैल्यू एंड ऑल दिस थिंग देयर तो दैट इज द बेस्ट पार्ट ऑफ आवर लर्निंग इन आवर वेबिनार्स तो दिस इज ऑल ममता जी आप हो जो चले गए हो
नहीं मैम
नहीं
हैड टू
ममता जी लॉग आउट किया है
लॉग आउट
शी
करा
हैड
है
हाँ उनका कोई ब्रीफिंग था शी हैड
Okay,
सेड दैट
okay, okay. She said, I didn't hear. Thank
अच्छा
you
सर
very
ये
much.
ओपिनियन एज ए IIPA आप देंगे कि हमको इंडिविजुअली जाके देना पड़ेगा ये IBBI को आज जो देना है ओपिनियन तो एज ए IIPA आप देंगे कि
सर देखिए
ऑन
हम लोग
बिहाफ
ये
ऑफ
करते हैं हम लोग ने डिस्कस कर लिया कि आपने ये ओपिनियन देना है आईपा के बिहाफ पे तो हम लोग दे देते हैं प्लस एज एन
हाँ
इंडिविजुअल जैसे मैं विटवर्थ के अंदर डायरेक्टर हूँ तो उनके बिहाफ पे भी हम लोग दे देते हैं बाकी जो है यू एज एन इंडिविजुअल हैज टू गिव योर ओपिनियन बाय लॉगिंग इन योरसेल्फ
जी ठीक है वो भी कर लेते हैं और क्या आज ही लास्ट डे है
आज ही लास्ट डेट है मैंने वेबिनार स्टार्ट होने से पहले ही कहा था कि जैसे ही ये वेबिनार खत्म हो तो अपना प्लीज ओपिनियन बना के आप कर दीजिए आईपा हमारी
जी
एसोसिएशन और एज एन इंडिविजुअल और एज आर आईपी हम लोग देंगे बाकी जिस जिसकी जैसे जैसे आईपी एंड ऑल दिस थिंग इज देयर दे कैन
राइट
गो
सर
फॉर
राइट
दैट
सर जी थैंक यू वेरी मच सर बहुत
Thank you for
वेरी गुड
थैंक यू सर
Thank
एंड
you.
थैंक यू पराग जी आल्सो फॉर जॉइनिंग अस थैंक यू
या
Yes,
फॉर
sir. My
कॉलिंग इन
pleasure.
आईपा थैंक यू
Thank you very
शांतनु
much. Thank you very much. With this note, I'm ending the meeting. Thank you especially to Shantanu ji, to Mr. Parag, to our guest Nipun ji, and all other participants also. Neeraj ji, Moli ji, Sandeep ji, Mehender ji, Deepak ji. Thank you very much. Thanks a lot. We go on doing all these meetings in the days to come also. Whenever any new amendment come out to be there. Thank you very much. Thanks a lot.